It's gorgeous up there. Please let me out. Please. Oh, the suffering in the tear. Everything is.
All right, so we're getting ready to review this extremely beautiful game. It's made by a gentleman named what's his name? Let's look up the artist of the video game. So I wanted to do a review of this video game because I saved it on my playlist, and going back looking at it, and I just stumbled on it one night, and it was just absolutely inspiring on so many levels, because the game was, I think, single-handedly designed and made by Zdzislaw Bezinski, and the gameplay that I watched was this channel called IGP or something like that. We'll go back to it. But when I tell you this game coverage was absolutely stunning and inspiring in such a deep and decrepit way, it's so difficult to try to make something that's decrepit and horrifying, but it still is so human that it draws you in. Because some horror is just repulsive and you don't want to like really engage with it. Or at least some, everyone's going to like something. But for me, I guess what I'm saying is personally, this kind of clicked as still having like such humanity while also being so, I've used the word decrepit, but just so like, of course it's like desolate. Let's try to see what kind of words we can use to make this a place of deserted people in a state of bleak and dismal emptiness. Yes, this is definitely desolate kind of area and desolate kind of vibe to the game once we get into it. So let's jump into it. I want to look more into this author. I thought he was a young guy. I didn't know he... Wait, hold on. Inspired by him. Okay. But who made the game, though? I know at one point he checks at one point early on to see who made the game. So I guess it was made by this page.
This island feels like it's maintained, untouched by time. The wind and the waves pause for a minute to rest, the calm before the storm.
Better resolution focusing on this camera right here. Blood. So yeah, I just took time to watch that one. All right.
So this is Necrophysis from the same developer. I know I make a lot of stupid jokes. You and Vic. Obviously, given the themes here, everything is wrapped up. Quite the experience to be. So this is Necrophysis from the same developer and 3D artist who made The Shore. It is an unbelievably atmospheric and abstract horror game that pretty much puts you into the surreal, ethereal world of Zdzisław Beksiński, the nightmare artist. And I gotta say, it is quite the experience to be put into this dude's work, because if you're familiar with it, the surrealism is insane. Now, I did go into this pretty blind, so I'm gonna give you a little piece of context, so that way you know more than I did going in. Obviously, given the themes here, everything is rather abstract, but we are waking up billions of years after the entire universe, but we are not but an unbelievably atmospheric and abstract horror game that pretty much puts you into the surreal, ethereal world of Zdzisław Beksiński, the nightmare artist. And I gotta say, it is quite the experience to be put into this dude's work, because if you're familiar with it, the surrealism is insane. Now, I did go into this pretty blind, so I'm gonna give you a little piece of context, so that way you know more than I did going in. Obviously, given the themes here, everything is rather abstract, but we are waking up billions of years after the entire universe has ended. And that's pretty much all you need to know. Anyway, I love this developer's work. He's a fantastic artist, and I think you guys are really going to enjoy this one. If you want to...
That's lonely to a whole nother level of waking up billions of years to just... And one thing that gets a lot into this, because I've already seen it once, is they get a lot into what happens after nothing. Like the remnants after eons and eons of waste and decay, the entropy of entropy. What does it look like? God. But yeah, so
play the demo for yourself. The link is down below. You should do that. Anyway, enjoy, my friends. All right, Eric. Blow me away, son. You and Beksiński. I'm already feeling it just from the main menu. Of course.
And in the palm of your hand, and and to see.
Did I miss that?
So another reason I want to review this gameplay by IGP. Shout out to IGP for the gameplay and the game studio for the demo. It's inspiring me, man. I just kind of want to share what inspires me about the visual surrounding, the gameplay. Not necessarily inspires me about the gameplay, but just the video game, and the artwork, and then the dialogue was also very interesting in how the game interacts.
Of course there are.
To see a world in a grain of sand, and a heaven in a wild flower. Hold infinity in the palm of your hand, and eternity in an hour.
We gotta take it back. I need to read this. To see a world in a grain of sand, and heaven in a wildflower. The world in a grain of sand, and heaven in a wildflower. So comparing the world to heaven. See heaven in a grain of sand, and heaven in a wildflower. A grain of sand is monotonous, is the foundation of this world, of this artwork. I wish I could To see a world in a grain of sand and a heaven in a wildflower. Yeah. So that's true. I think they're kind of just setting up the background for the video.
In a wild flower, hold infinity in the palm of your hand, and eternity in an hour.
Infinity in the palm of your hand. So limitlessness in the palm of your hand, and eternity in an hour. Eternity is long periods of time, so you're just watching long periods of time just go by, hour after hour, while you have infinity in your hand. So is that what you're being gifted right now? You're being gifted infinity.
Oh, I'm waking up. Again, all the models and stuff, I believe majority of it, if not all of it, was custom made by the developer. He is an artist first. That's why we got a game like The Shore and
What's
others.
the artist's name? Who's the artist? That's what I want
Yeah.
to
Hi, good sir. Do you want me to... No. You to interact.
see. So in this game, you
This
gotta
is
like
beautiful.
solve like simple puzzles.
How's it hanging, buddy? I know I make a lot of stupid jokes. Sorry about that. Don't mean to break the tone here. I instantly feel dread, which I feel like is the point of Beksinski. Hello?
If necessary, more flesh and bone will be formed. Ugh, why is it putting flesh and bone? Like, who's controlling this world, this universe? What controls it? Oh. Man, yeah, this is some heady stuff. I want he's gonna go to the. I want to know the developer of this company, Dragonis Games Official. I need to know their company now. That's what I need to know. I need to know about it. Who owns?
This island feels like it's maintained, untouched by time. The wind and the waves pause for a minute to rest, the calm before the storm.
worst stream of my life. Let me see.
Necessary more flesh and bone
But look,
will
look
be
at some of
formed.
these shots.
Oh, please no.
It's 'cause he-
2 eyeballs. So where's the other one? This is on you? Yeah, read it. Ooh, wall of sand, a barrier. There is nothing beyond. The way forward lies elsewhere. Oh shit. Okay, I'm trapped in here. What are you? Are you special? Wisdom requires payment? Okay. Well,
we gonna- All right. All right, so it looks like we might have found something worth looking at. So these are the new rules that are going to affect small businesses. Let's have a look here. The following are proposed rules of possible interest to small businesses published in the Illinois Register. Individuals have the opportunity to express their comment. Note, agency economic impact analysis are provided by rulemaking agencies and do not necessarily reflect the positions of species conservation, nursing homes, sales taxes, tax credits, physician licensure, behavior analysis, loan guarantees, rulemaking agencies. What laws would be interesting? What laws? Sales taxes, tax credits, 7 tax credits. So what I'm here, I'm just looking for something interesting. Just scrolling the internet, kind of like just wasting my days. But I don't know, like I wanted to stream about the video I was showing earlier, but then I didn't really want to stream about that. So I just started looking for new Illinois business laws. I need to do a lot more stuff that is more important, but you know, working my way to it, working my way through it, just trying to live a bit more, you know, better and authentically. So just I feel like part of me getting on lives is just to turn the camera on and start, man, and just to, if it's as easy as pressing a button, I'm gonna press that button, you know, and just at least try to do something. Yeah, it's still like a lazy version of doing something, but I got irons and other fires, and I'm gonna have to start get up, moving around. But yeah, it's something, and it's a skill that like once you start doing it, you realize like how you can engage and like get used to engaging, because it's not, because you're in the theater of your mind all the time. So for me, I thought translating it to being vocal and entertaining, and I'm entertaining with my friends sometimes when I'm in the mood and getting good feedback, like that kind of stuff is funny. But to turn it on and off is a different story. Because even sometimes in your mind, you're not trying to always be going back and forth and really be thinking. You just chilling, trying to be entertained, watching some kind of entertainment. But I don't think that's the best life. I don't think that's the most. A life well lived is one not spent in reflection. But Islam does stress this concept of knowledge that is not beneficial. So knowledge that is not beneficial is actually bad. Like you shouldn't, if you shouldn't just learn stuff to learn it. But I don't think that comes up. I don't think that I always thought that meant you couldn't be a polymath, when I don't think that's what that's saying. Because being a polymath and being, you know, someone who's abreast with all the sciences that they can be, I think that's important, because then you can correlate them to the one truth, or the living truth. So So what does non-beneficial knowledge mean? Like baseball stats? Baseball like is so they love their stats more than anything else in the world. Um, but could knowing that, like keeping track of that, is truly a fruitless human endeavor. And if people focus on that, it's more they can't focus on the inner meanings of philosophy, religion, geology, biology, chemistry, aerospace, the arts, plays that really make you reflect, plays that push, understanding different kinds of arts, calligraphy, and other cultures have their forms of expression, but I doubt, that every culture, men do like go play sports sometimes, but imagine building your whole society over what men's can play sports the best. Like it's kind of offends the consciousness a little bit when you think about it. So they're not. I don't know how to understand this. I can't. Okay, so they're supposed to be telling us about laws that could affect small businesses. It's not very clear at all what the heck they're saying. So basically, so they're saying none of these laws are affecting. I gotta figure out what area of law I want to master, man. I really do. I thought I was signed in on this. Hold on, let me. So Claude is pretty good. What do we want to ask Claude today? All right, we want to ask Claude about do you know how many I gotta be careful with my questions for Claude because they're so good. I hope I can keep the ones that I have asked before. Please provide an outline of What areas are the cause for most bro? We got an LLC case. Let's do it. Let's see if I can find some good stuff out of this case.
Case on our call this morning is agenda number 5130-539.
I got a picture with this brother right
Armory,
here.
LLC versus Kwame Raoul. Counsel for the appellant, are you prepared to proceed? Counsel?
Audio isn't the best, is it? Beautiful courtroom. Absolutely beautiful courtroom.
Good morning. May it please the court. Deputy Solicitor General Alex Hemmer for the Attorney General.
Check out the law
For
students in the
60
back
years,
there.
the General Assembly has
I
enacted
like law.
venue
I'm
rules
free
that
law.
channel civil
Shout out.
litigation
I'm
towards
just joking.
certain
I'm just joking.
counties
I love
away
it.
from
That was me
others.
back in the day
The Circuit Court in
when I
this
was
case held
30.
that one of those venue
undergrad
rules,
late.
Section 2101.5 of the Code of Civil Procedure, violates
Uh-oh.
due process principles by
Wait.
requiring that some civil cases
Rewind, nigga. Sorry, my bad. Not nigga.
Good morning. May it please the court. Deputy Solicitor General Alex Hemmer for the Attorney General. For 60 years, the General Assembly has enacted venue rules that channel civil litigation towards certain counties and away from others. The Circuit Court in this case held that one of those venue rules, Section 2101.5 of the Code of Civil Procedure, violates due process principles by requiring that some civil cases challenging state statutes and regulations on constitutional grounds, be brought in Sangamon or Cook County. The Circuit Court did so on the thinnest possible record. 2 declarations asserting that it would be more, quote, convenient to litigate this case in Madison County than here in Sangamon County, an additional hour away. That showing cannot be enough to establish that a venue rule violates the Due Process Clause. If affirmed, the Circuit Court's opinion would pave the way for due process challenges to every venue rule in the Code of Civil Procedure.
Counsel, can we somewhat lay the foundation? Is this an as-applied challenge or a facial challenge?
So you'd have to ask plaintiff's counsel how he understands the scope of the due process claim here. The court's opinion certainly is a facial holding. It holds that the statute is unconstitutional as to anyone who does not reside in Cook or Sangamon counties. And so understood, I think the court's opinion is clearly incorrect because the statute is constitutional in many cases, including plaintiff's own case. And that's why I think, although we would welcome an opinion sort of explaining that the court is categorically constitutional in many cases, at minimum, we think the court should reverse on the basis of the present record in which plaintiff supported its due process challenge only on the basis of this sort of assertion of inconvenience.
And can we have this discussion about inconvenience? Is that the right inquiry? Is that what we should be asking ourselves? Do we need to even address forum nonconvenience here in this matter?
No, Your Honor, you do not need to address forum nonconvenience, especially now that plaintiff, as I understand it, has sort of foregone any argument about that issue. Again, you can talk to him about that, but that's my understanding scope of
That's
the
a great
case.
point.
And as to your original
gotta raise
question,
it.
Justice Holder-White,
If you got an issue, you got to raise it. Because you can't go back and say, oh yeah, I had an issue with that. Like if you had an issue with that back then, why didn't you raise it in the legal? And unless you had a good reason, the law will always hear. The law isn't about being strict; it's about making sense. So if you have a good reason why you didn't raise it, they'll hear. But if you don't got a good reason, then just because you thought of it later, that's not what we're trying to do. We're trying to deal with injuries. And if you had an injury, you would have thought to mention it to the court, instead of just trying to make an injury where now that it may help your case. Let me see. So it sounds like this. I didn't know they had these kind of cases on access at Illinois courts. I'm about to really go in on these. I'm about to go do some work beforehand on these and really dig into some of these cases. I wish there was an easy way to get a summary of the case. Some of these cases might be decided already. It's always cool to see when the case is decided what you can do. I always like the ones up with business names in them because all of these are probably going to be court cases and stuff like that. But I need to figure out how a good summary. Wait, let me see. What happens if I take a docket number for this one and then just search it somewhere and just be like, Is there a summary? I guess ain't nobody writing summaries. All right, so I'm trying to see about this one. I'm trying to see about 130337. So it's this one, 130337. So let's see appellant's brief. Let's see what the issue is with this case. The issue with this case is nature of the case. Nature of the case. We'll go straight to 1, see the nature of the case. Rebecca Petta appeals an order from the appellate court. So we at the highest level, we're at the Illinois Supreme Court. This is an Illinois Supreme Court case. So at the lower court, her dismissal of her complaint was upheld. So the first court ruled against her, the second court ruled against her. Now she's at the third highest court, and the Supreme Court has agreed to hear it. I'm not sure if the Supreme Court has to hear all cases, or if it's like the U.S. Supreme Court where they don't have to. Petta brought an action against the company. It's called Christie. Petta versus Christie, for harm caused by a data breach where cybercriminals successfully intruded into Christie's account and gained access to patients, include his highly sensitive personal health. So it seems like she got a good case just from alleging allegations. I don't think that would pass we need more facts. So she's saying there was a data breach, which I guess that is a fact. But when did the data breach occur? Anyway, after the breach, Petta received numerous phone calls, sent multiple emails to open fraudulent bank accounts. Pleasure, but may also have also used her social, all of which was stolen during the breach. Petta alleged that she suffered harm from the misuse of her data. She alleges that so they granted Christie's motion to dismiss, but rejected its argument that Peter lacked standing. Because you see what I was going with that? Because initially, the nature of the case, and if that's how they pleaded their complaint, you need, like, since Quambi and Iqbal, I'm not sure if that applies to state cases, but motion, if you have to plead facts, you can't just say this stuff happened, this stuff happened, this stuff happened, so now let me get discovery to prove it happened. You have to say, on this day, the data was stolen, and I know it because this person told me. Otherwise, it's just a fishing expedition, and the court doesn't like fishing expeditions. The courts, so that's why the motion to dismiss was probably granted Petta's complaint, but rejected its argument that Petta lacked standing. So they thought Petta had standing, but no well pleaded complaint. However, the court dismissed her claims for negligence and violation of Illinois personal for failure to state a claim. You gotta state a claim, baby girl. I smelled that one on the way. As soon as I started seeing stuff like Petta brought an action for harm caused by a data breach during which cybercriminal. You don't even say what date. You don't got no date. You don't got what cybercriminal. You don't got like how you know that a little bit. Why do we think that this person has a data breach? Like, how do we know they had a data breach? You're saying they did. That those are just baseless claims. Which you can make some claims, but you got to have a little bit more bite to them. You got to have something like, oh, this person, I saw them throwing out trash in an unapproved manner, and there been a string of burglaries nearby of garbage cans where people were stealing information. You have to have a reason why you think Christie did these things. You can't just say caused. Well, I'm sure this is not her whole complaint. I'm sure she made, but obviously it's an issue. It's an issue if the trial court ruled against her, and under that, and she couldn't even get it under the different act. So that was probably the common law she was suing under. The Becker appeals from order, but on different grounds than the trial court's orders. Pettis appealed to the court's order to the appealed the lower court to the 5th District. On this date in the 5th District, they upheld the dismissal of Pettis' complaint, reversing the trial court's determination, properly alleging this. Also, they said she didn't have standing to begin with. So they went back on standing. Now the statement of issues for this case. Whether the theft of patient's personal information in a data breach constitutes a cognizable interest sufficient for standing when the stolen information is used. So basically, did something bad happen to you? Is the theft of your personal medical information in a data breach a cognizable? Do you have a right over that, basically? Sufficient for standing when stolen information is used to attempt fraud. So like, did something bad happen to you? If your personal information gets stolen and someone attempts fraud and identity theft after the breach, did something bad happen to you? Okay. Whether a medical provider that collects and stores sensitive personal and medical information owes its patients a common law duty to reasonably safeguard that information when its adequate data security contribution to a risk of harm and data breach and resulting harm to its patients was foreseeable. So you always got to look for words like this. Common law duty. So we got reasonably safeguard. That these are words that matter. Reasonably safeguard. Did they have the responsibility to reasonably safeguard information that when it's inadequately so all I'm trying to say is word like this, you have to really, because they change what you're talking about. You have to account for all of these things. Was foreseeable. And then things like reasonably safeguard. I always look for reasonably, because that doesn't mean you have to go up and beyond to the end of the world. You got to do what's reasonable. You got to lock the door when you leave. You don't have to pay for a security guard to come watch the door. State and federal law already require the defendant to implement reasonable data security, and the burden of imposing such duty is. So this is a long statement of an issue. Whether a medical provider that collects and all this stuff So this is the last modifying, and the duty is minimal. So if you don't got to do that much, but I thought that should be baked into reasonably. Oh, and the burden of imposing such a duty. So I guess that mean the courts who imposing such a duty. Oh, I guess that means the business cost of making people do that. Okay, I'll be here. The door is unlocked. Abby got a package. Good. Just doing some research and stuff. All right. So first issue was a lot more simpler. Are you injured when your information is stolen and used? Or is it attempted fraud? So not actual fraud. I guess it wouldn't be a question. If it was an actual fraud, it would be less of a question. This one, I'm not really, you got to read this a few times to really understand what it means, or I do at least. Whether a medical provider that collects and stores sensitive personal medical information owes its patients a common law duty to reasonably safeguard that information when its inadequate data security contributed to a risk of harm and a data breach and resulting harm to patients was foreseeable. State and federal law already require the defendant and the burden of So this is what we're establishing, a common law duty to reasonably safeguard information. But then when These are like the additional modifying phrases. When it's adequate, contribute to a risk of harm, and that it was foreseeable. Also, these are all the provisions. So what we're actually doing is deciding whether a medical provider that collects and stores sensitive personal medical information owes its patients a common law duty to reasonably safeguard the information. But they only saying you're going to have to reasonably safeguard it when these things happen. When these things happen, that's when you have to reasonably safeguard information. If these things don't happen, you don't have to reasonably safeguard it. Or that's when you haven't violated the duty. So that's the best as I can understand that. So that's about reasonably safeguarded information when you store medical and personal information by a medical provider. 3, whether a medical provider loss doctrine is inapplicable here. As here, the duty at issue does not arise in contract, the case presents no risk of limitless liability to unknown plaintiffs, and where liability is to a defined group of individuals impacted by a data breach, and the plaintiff's harm is not purely economic. The economic loss doctrine. So that's an entire doctrine that I don't really know about. So they're trying to see if it's applicable here. Then they state the facts where the duty at issue does not arise in contract. So there wasn't no contract, just somebody, your data was stolen, I guess. Whether the plaintiffs may assert a claim for a violation of the Illinois Personal Information Act under the Consumer Fraud Act for the diminished value of her sensitive personal diminished value. So now we're saying that that we all know that our information is going to get stolen. So now it's worthless when it gets stolen. That's a very unique kind of view. So this was which one of those issues would I care about the most? This one is a big issue. This one is a big issue because this has the most effect for if you're going to have more cases come down the line, or if the court allows this, they're going to have a lot more cases to decide in the courthouse, which is never ideal. But you don't want to take away someone's right just because you don't want to have to litigate it because of time. But cognizable interest. So you have to, but a cognizable interest is a big test. So anytime you're asking a court to decide what a cognizable interest is, and they actually take the case up to decide it, that's pretty big. So this case I would say, is going to be big just on that factor of further outlining cognizable interest, because that goes into standing and whether you can actually bring a case in the first place. So cognizable interest is a big one. The rest of this stuff is big too, but much more specific, a lot more conditional phrases. Like this one is straight up, like whether the theft of personal medical information in a data breach constitutes a cognizable interest sufficient for standing when stolen information is used in attempted fraud, identity theft after the breach. That's pretty straightforward. Everyone knows exactly what you're talking about. It's not exactly super case specific. This stuff is very case specific, it seems like, or it's a lot more barriers to like starting a case. So that's cool. All right, so that's kind of what that case. We got a good idea about what this case is about. Cognizable interest for standing, and then we got all these medical. The different doctrines apply and different acts apply. We're just about the value of her. So what's at issue in this case is someone's information was stolen. Someone's information was stolen, and my parents just got home. Someone's information was stolen, and now and now someone was getting calls and fraudulent attempts on their phone call, and they have their information just out there. So that's what this case is about, and they're talking about what can they do about it, basically, which is big. So let's see how they argue that case now that we understand kind of what it's about. But first, I'm gonna pause for a minute and go downstairs and see what's up with my peoples. You got two girls. right, so let's see. Let's see what kind of cases and questions the judges ask. Hopefully we can hear it pretty good. We'll see.
This morning, our first case is agenda number 7, number 130337, Rebecca Petta, etc. versus Christie Business Holding Company, PC.
Rebecca Petta took it all the way to the Supreme Court. She said, I want answers. You lost my data. I want answers. I want to get paid.
Good morning, Your Honors. May it please the Court.
Got Hayden Panettiere in the background.
My name is Michael Laird, and I'm here on behalf of Rebecca Petta. Ms. Petta is a patient of the defendant, Christie Clinic, and she brought this case concerning a data breach that Christie experienced in 2021, and she alleges resulted in the theft of her
Alleges, that's a problem thing. Okay, I got to make more than just allegations. We need some facts.
data and misuse.
Wait, hold on. I'm sorry, y'all. I got to do this. This is what we need to look up what we call the Twombly and Iqbal standard. What does it say? What's that standard say? The complaint must include enough facts to show that the claim is more than just possible, but reasonable and likely to have occurred. Complaint must include enough facts to raise a reasonable expectation that discovery will reveal enough. You got to include enough facts. It's just about facts, man. Complaint must show for each element of the claim. So if you got to prove intent, cause, harm, and damages, you got to prove that like you got enough facts to show each one of them. Okay. How we gonna go? All right, so that's what I mean. Because like when I said like he just be alleging stuff, homie just be alleging. But I like the U.S. courts interface. It's really nice.
Misuse and subsequent fraudulent loan applications. The issue presented by this case generally is when and whether a data breach victim in Illinois has the opportunity to bring a claim against an entity like Christie Clinic, who she contends failed to adequately secure her personal information.
Type stuff.
These are cases that are largely going forward throughout the country, but because of several questions that are before the court today, have not really gone forward in Illinois. Those questions include the issue of standing, when and whether a data breach victim has suffered an injury in fact sufficient to bring a case against the defendant, and more specifically, whether or not fraud after a data breach is sufficient injury to establish that concrete injury for standing, but also what claims she may bring against a defendant who does, or at least is alleged to have inadequately secured her information. Plaintiff here alleges that the defendant had a duty of negligence, and that it breached its duty. And that question, whether they had a duty to the plaintiff in this case and in other cases, is also before the court. And finally, the question of economic loss doctrine. Even if defendant does have a duty, does that doctrine prevent plaintiff from bringing a claim? I'll start with the issue of standing. This is an issue that's been litigated repeatedly in federal court over the past decade. It's an issue of first impression before this court.
That's what's crazy though. Like, how are we just not having this case in 2025 in Illinois? We're basically saying, can you bring a case if someone tries to use your information for fraud? If you gave someone your information, they lost it, and now now people are trying to use your information for fraud. That question apparently has already been handled in the federal courts, but we're just now handling it in Illinois state courts, which is crazy.
But if you look at what the federal courts have done, they've largely, starting at a point of variance, they've largely come to a position where they have general factors and general things that they're looking for in these data breach cases to see if a data breach victim has standing. One of the big questions is whether or not there was fraud after the data breach. Almost all of these courts recognize that when there's fraud after a data breach, that is sufficient for standing. And that's for a couple of reasons. The fraud after the data breach tells us something about what likely happened in the data breach. Generally in these cases, data breach victims don't really know. We have to rely on what the defendant is willing to tell us. And as other courts have recognized, including the 11th Circuit and Ramirez, defendants, for good reason, withhold a lot of information about what happened in the data breach because they don't want a subsequent data breach, or they don't want other people to gain information about how their systems operate. So plaintiffs come at these cases at a point of informational disadvantage. But when you have fraud after a data breach, that suggests
He's kind of making an argument and say, hey, let my complaint kind of be missing some facts because I'm disadvantaged in this way.
something about what happened in the data breach itself.
Counsel, describe for me what you contend is fraud after the data breach
Well,
in this case.
I think fraud in this case is the misuse of Ms. Petta's information in the series of fraudulent loan applications that occurred after the data breach, but before the defendant had even notified plaintiff or other patients of the data breach.
What ties those loan applications to this specific data breach?
I think that's a great question, and it's really probably the key question here. When you have these data breaches, as the 5th District recognized, and unfortunately I told this to the 5th District, and they put it in their order, the hacker isn't here, or the criminal who commits the fraud is never before the court. So we don't get the opportunity to ask that criminal,
how are they
where did you get
connected?
this
How are they
information that you
connected,
used
buddy?
in these loan applications? We have to piece together through circumstantial evidence what is the most likely scenario, or at least at this pleading
So after you piece it together, what did it say? That's what we're waiting to hear, buddy.
stage. Is it reasonable to infer that data came from the data breach?
So may I ask, there's been, we're at a pleading stage, of course.
Right.
And there's been a lot of discussion about what's actually in the complaint, what was actually alleged. Here when you're talking about fraud. So it's apparently, I will admit I've not read every word of the complaint, but the appellate court summarizes, or not summarizes.
That's one of the issues before the court. Or is it? I don't know if it is.
Quotes this. Since the data breach, Petta has experienced suspicious behavior in the connection with her phone number and address.
Suspicious behavior is way vague. You see why the judge looked at it like, really, bro? Suspicious behavior and a complaint to the court? Okay.
Phone number, city, and state have been used to, apparently, I will admit I've not read every word of the complaint, but the appellate court summarizes, or not summarizes, quotes this. Since the data breach, Petta has experienced suspicious behavior in the connection with her phone number and address. Her phone number, city, and state have been used to connect with a loan application at First Financial Bank, Columbus, Ohio, in someone else's name. Petta received multiple phone calls in recent months regarding loan applications she did not initiate. And so the question is raised whether that allegation is sufficient to trigger what you're talking about, what happened when there's fraud.
Wait.
Suspicious behavior, a loan application with phone number, city, and state, it's not in her name, and then multiple phone calls. Is that sufficient to plead this idea of fraud?
And counsel, I would add to that question the fact that the appellate court referenced the fact that the information allegedly used is readily available using a Google search. How does that impact our analysis?
So I think the crux of the question is the use of this non-sensitive information that is available online sufficient to say data was taken in a data breach? I think that's a case-by-case inquiry.
Credit to this guy, because he's fighting an uphill battle, at least what it looked like, and he's keeping his composure, like, you know, and still exuding confidence. So shout out to this attorney doing his thing. Nice suit and tie combo, by the way.
And in this case, I think it's sufficient for a few reasons. One is, as we allege in the complaint, we know why entities generally target healthcare companies like Christie Clinic. And that's because the value of the data that healthcare entities have is significant on the dark web. Healthcare entities have medical information, insurance information, social security numbers, all of which can be used for a variety of fraudulent schemes. So we know generally why healthcare entities are targeted. In addition to that, we know the hacker here had access to that information from the defendant's notice. They acknowledged that this hacker was on their system for 30 days, had access to this information, and they can't tell in their investigation how much of that data the hacker took. So already we're at a position where, in my view, there's enough to say that most likely this hacker here is trying to get this data. Now, we don't know what happened, but when you see fraud and misuse of some of the same information that the defendant has admitted was exposed in the data breach, it suggests something about the hacker's motives here.
That's a great point, because The question about all her information was already available online, and your complaint said this information was used. So why they connect to this specific data breach? This is perfect. She was like, hey, this stuff wasn't happening when my stuff was already available. So now that almost acts as a control in the experiment. So it goes from being a negative to a super positive to her case. Like, my information was already available, and then no fraud attempts. But that information that was available is now being used in fraud attempts after this data breach. So why wasn't it being used before that?
Well, let's go back to where we are in terms of pleading.
But there's also maybe a lot of reasons it's not, because maybe it just took time for the fraudsters to use the publicly available information, so it's not foolproof, but it's not a definite like it may have sounded.
Questions, because that's start just real
Great lawyering, though. Great lawyering.
basics, civil procedure 101 for the students here.
Yes.
Right. Is this language that I just read you?
Yeah, hear what she said? That's what I said before. This is this is what the first day of law school. Is this a well-pleaded complaint? Basic rule of all civil procedure, because otherwise the court would be dealing with everybody who just scribbled on a piece of paper.
Suspicious behavior, multiple phone calls, the use of her phone number and city and state. Is that sufficient to plead what you are construing as perhaps fraud?
And fraud is important because that is what establishes standing in this case. You don't have standing unless someone tried to use your information for fraud, but you have to prove that someone tried to use it for fraud. You can't just say it.
Two responses to that. This is identity theft under Illinois statute. So even if it's not fraud, the use of somebody's phone number and address is identity theft under the statute. But it's not the nature of the data that is, I think, important. It is what is happening with that data and what it suggests about the data breach itself. This person who submitted these loan applications got this data from somewhere. The close proximity to a data breach where the same information was exposed links these two things because they're happening close in time. And if you look at how federal...
Is there a time frame pled?
It's not pled. It's not pled.
So it's not pled.
Right. It's not pled.
We can't talk about that. That's not a factor. Close in time is not a factor. It's not in the complaint.
I think we can a little bit because the notice... So that we filed the complaint, I believe, in April of 2022, and the data breach occurred in July and August of 2021. So that's a several-month period. Now, I can attest to the court, and as I've said, it's not specifically stated in the complaint, and that is something that we could amend to add in. It happened in January of 2022.
But, again, this is a pleading question. We're just looking at the complaint. This is all we can look at.
Bruh said, let's talk about a complaint that's not in front of us when we're deciding what's in the complaint. Bruh, that's like your waste. This question is at least a waste of time.
What's in the complaint? And you agree that that time frame is not pled?
I agree that it's not pled, but it can be inferred given the date that we filed the complaint, that it would be within that time frame. And I still think that time frame would be a sufficiently close point in time for these two things to be reasonably connected. And if you look at how other courts treat this question, the fairly traceability question of whether a fraud is related to a data breach, generally there's only two instances in which courts would not presume or at least believe that these two things could have plausibly been connected. That's where there's not a logical connection between the breach and the fraud, or the timing doesn't work out right. The logical connection just asks, is the information that was exposed, can it be used for the type of fraud that occurred? Here we have loan applications, and one thing, going back to the pleading, we did acknowledge that there were multiple loans taken out. We don't know whether or not her social security number was used.
Loans taken out?
Or no, I'm sorry, loan applications made in her name. And we're using her information. We don't know whether or not her social security number would have been used there. We would need discovery to figure that out. But we do allege that the social security number was impacted by the data breach pursuant to defendant's own notice.
Counsel, what was the plaintiff's injury here? What's the real, distinct, specific injury that she suffered?
I think the injury in these cases are the loss in control.
No,
This case, talking about some of these cases.
I'm talking about in this specific case, not in these cases, in this case.
I think the injury here, among the misuse of her data, is the loss of control of her sensitive information. In paragraph 56 of our complaint, we point out that consumers would pay to keep this data safe if they could. They would pay $30 to $50 if they could guarantee their private information would never be accessed or taken by criminals. There is some value, or there's value to a feature of this data.
So what is the injury?
It's the loss of control of that data. Once this data becomes, this is private information. We're talking about medical information, social security numbers, insurance information, all impacted by the data breach. Once that is taken out of plaintiff's hands, there's a privacy interest loss there, because this is sensitive information that she wouldn't want to disclose to anyone else, and generally you never disclose your medical information to other people. And also a loss of control of this data.
Counsel, when you say there's value attached to the data, isn't that speculative?
I don't think so. I don't think so.
What's the value of it?
The way to measure the value, I think, is through studies like we cited in paragraph 56. If people are willing to pay to keep their data private and within their control, then that is a feature of the data that is lost when the information is breached and put out either on the dark web or put in the hands of cyber criminals. So you can measure the value loss of this data. And
I agree with that point.
I think crudely, courts have recognized that as a potential damages that data breach victims experience. They call it the diminution of the value of the data. And this is something that courts recognized throughout the country. So I think the heart of the injury is the loss of control and privacy of the data. And the misuse of that information is what helps us reasonably infer that plaintiff's data is now in the hands of cyber criminals, in addition to everything we know about the data breach. The fact that this hacker had access to this information for 30 days. Christy likes to point out that they had access to a business email account, but it's a huge red flag in an entity cybersecurity that a business email account had access to healthcare information, medical information, and social security numbers. That's a huge red flag for cybersecurity, because normally you segregate. If you have people working in business, they don't have access to all of the sensitive information that is located elsewhere. But this one email account had access to everything. That's a big red flag for Christie's cybersecurity. The other big red flag is Christie's investigation of the data breach. These are very technical and highly sophisticated, and normally you can get a good idea of what the hacker did within your system. And you use logging and monitoring to track exactly what the hacker is doing, accessing, and taking out of your system. Christie wasn't able to tell any of that with respect to this hacker. It couldn't figure out exactly what the hacker was taking out of its system or how much data it took out of its system.
That is bad.
That suggests that's a big red flag for its cybersecurity. So when you have a situation where we know entities like Christie are being targeted to take this data, you have a hacker who is in the system for 30 days, which is plenty of time to obtain the data. You have access to the data pursuant to defendant's own notice about the data breach. And then all of that combined with the fact that we suddenly see misuse soon after the data breach occurring suggests that this data is in the hands of cyber criminals and it's out of plaintiff's control.
Counsel, does the letter from Christie state that the data that any data related to your client was actually taken, or did the letter state that it was exposed to these cyber criminals?
They said it may have contained that information, but the point there, I think at this stage, reasonable inferences are drawn in favor of the plaintiff. The defendant doesn't know what happened in this data breach.
The notice should be enough.
It can't figure out why the hacker breached its system.
The notice should be enough.
But yet it asks.
Your biggest issue, bro, is you didn't plead the fact that my plaintiff's information had been previously. This kind of information had been previously available on the internet, and no fraud attempts were made. I received this notice from this medical company saying that my data had been exposed, and now I'm getting fraud alerts, including information that was previously available. But right now, he didn't plead the timing in his complaint. But he's saying my complaint came after the notice of the breach and the breach, so you can reasonably infer that that's why.
Asks the court to infer that the hacker was there for an independent reason than the valuable data that most hackers are targeting. The defendant doesn't know what the hacker all accessed, yet it's asking the court to infer that it accessed nothing. It doesn't know how much data was taken off its system, yet it asked this court to infer that no data was taken off the system.
But we're back to the pleading question.
Yeah.
This is what you pled. The 2615-19 motion was filed saying that your client didn't have standing. Right? So at this point, don't you have to somehow find, isn't the burden on you now to show all the issues that we're talking about? Where is the fraud? Where is the injury?
I don't like that.
I don't think that's the way courts generally treat it. When you have, these are two unique events. Most people don't expect.
Because he's basically, at some point, he's saying, no, I did plead enough. And he was like, but like, didn't you, like, now that they said you didn't plead enough, don't you got to show that you didn't plead enough? No, like, he gets the first benefit of the inference. Because when he plead his complaint, you're supposed to give, I forget how it's phrased, but the entrance of the facts goes to the, if the facts, like I said, this is a perfect example. You get a notice saying that your data has been exposed and may have been taken. They don't get the inference that no data was taken when the inference could go either way, especially a reasonable inference.
Experience data breaches that often. Most people don't experience the misuse of their information that often, where they're getting phone calls saying someone's trying to take out a loan using your information, multiple phone calls. So I think at this point you can, through reasonable inferences about what we know about the data breach and what we know about the potential connection between the fraud and the data breach, that it's sufficient to say that the cyber criminal was targeting the information and actually obtained it. And if you look at, this is an issue that's been litigated over and over again. And if you look at the way that other courts have treated it, they presume that these two things are related.
They stayed on standing the whole argument. Y'all remember these other things that we saw? Bruh. Well, that's at least how they stated the issues, and this is how the other side stated their issues. They stated the issues very differently, and you can see why by reading them. But look how simple their statement of facts is. Plaintiff's statement of facts takes many liberties, straying far from allegations of her own complaint. These are pertinent facts. These are the pertinent facts and allegations, well pleaded and otherwise. Well, overall, I'm getting the vibe that the court doesn't like this complaint at all, and doesn't like the plaintiff's case here. We're going to look it up to see if it's been decided after this.
Versus Southern Independent Bank said, of course, when you have two unique events occurring in close proximity that are known to be causally related, it's reasonable to presume here that they're related. If you look at...
Counsel, it's your position that you don't have a burden at the pleading stage facing the petition that was filed, the motion that was filed?
Of course not. Our burden is to allege facts that we know and are sufficient to draw reasonable inferences about what happened. And
well, you're using the word presumption a lot, and so we know that to establish standing, that you have to have three things. You have to, the injury has to be distinct and palpable, fairly traceable to defendant's actions, and substantially likely to be prevented or redressed by the grant of the requested relief. Have you shown that in response to this motion?
I think we have. As other courts have found, the misuse of data after a data breach is a present injury that victims suffer. This is identity theft under Illinois' statute, and we can fairly trace it to the data breach given what we know occurred in the data breach, given that we know that hackers generally are targeting this information to obtain it, to misuse it for fraud. We point out in the complaint that the value of this data, the reason entities like Christie are generally targeted, is because this data can be used in a wide variety.
So he's basically it sounds like common sense, but he doesn't know if, like, another narrative of why this data hack happened. One of her competitors just wanted to make her business look bad, and they don't want to use any of the customer data. And in that sense, there is no injury to this person.
Fraudulent schemes, including financial fraud, which is what was attempted here. In paragraph 55 of our complaint, we explain how that fraud might look. Because of this information, because it's static and it can't be easily changed by consumers, you can attempt a series of fraudulent
They're not going to
loan
get to most of the other issues.
That is exactly what we're seeing here. So what we would expect if this data breach occurred as they usually do, a hacker entered the system to take data and either put it on the dark web or use it for fraud themselves, we would expect in that case fraud very similar to what we're seeing here, the misuse of the data. Now,
Counsel, I want to ask you to take it off in a different direction. This is a class action, right?
correct.
Is the plaintiff alleging that she has standing to represent all members of the class?
Great
involved?
question.
And if so, why?
Amazing question.
I think, so the question for standing with respect to a class representative is not whether each individual class member has standing, but whether she has standing. So if she has standing in her own right, then she has standing on behalf of the class. The only time that would not work out is if there's a conflict of interest between her harm and her claims and
His
the classes.
statement doesn't sound
and
right.
Here they are in unison, because you have a class that we allege had their data impacted by this data breach as well, and because she experienced fraud, it was either used by these hackers for fraud. So because of the similarities between the facts, her facts and the class members' facts, they were both impacted by the same data breach, the same data was impacted, and the potential harms, the theft and misuse of their data, that is sufficient for her to represent their interests in a class action.
And one other quick question. The plaintiff was offered free credit monitoring, right?
Correct.
And she declined that?
Yes, and most data breach victims do for good reason. You know, this is defendant who breached their data, asking them to give them more data and promising them now that we'll take care of your information. So I don't think you can hold it against her that she wouldn't go that route. Instead, she took time to monitor her own accounts and make sure that information wasn't being misused. And that's something that many data breach victims do. I only have a few minutes left. I can continue to address standing if the court would like, or I can move on to negligence very quickly. And what I'll say about that is, what's important about the negligence claim is where the duty arises. Here it arises in the common law.
So for negligence, you need a duty, you need somebody to violate that duty, you need causation, and then you need damages. So you gotta have owed somebody to do something. So you go into a supermarket, they owe you to have floors you can walk on. So if there's water on the floor and you slip, they had a duty to keep the floors clean. You were injured. Well, how does it go? I think it goes duty, causation, harm. Yeah, let me see. Oh, excuse me. Duty, breach. Yeah, duty, breach. So you have a duty, someone breaches that duty, and they're the cause, and then your damages. And damages is a harm. Like they can have a duty, they can breach it. So if you're going in the supermarket, and you slip and fall on the floor, they had a duty to make sure you didn't slip. They breached that duty because they left water on the floor unattended. Causation is, but for them leaving the water on the floor, you wouldn't have fallen. And proximate cause is leaving the water on the floor is reasonably foreseeable that someone would slip and fall on it. But if all that happens and you slip, fall, then stand up and say, "Wow, nothing's wrong with me. I don't feel embarrassed. I don't feel hurt. I don't feel anything." You don't have a claim. Something has to be wrong with you if all four of them are upheld. Boom. All right. So let's see. They're almost over.
The notion that an entity that takes acts that can create a foreseeable risk of harm for somebody else triggers a duty. That duty is to mitigate the risk of harm that it created. That is a well-established common law duty. We are not here proposing an affirmative duty, and I think sometimes that's how defense characterizes it. We're not alleging that every company ever has to protect every piece of data that they have against any data breach or disclosure whatsoever. And
Counsel, would you bring your remarks to a close?
Oh, I'm so sorry. Thank you, Your Honors, and I'll let defense counsel speak.
Thank you very much. Counsel for the appellate.
Madam Chief Justice, and may it please the court, John Amarillo for Defendant Christie Clinic. I think it's clear from the briefs and the questions that we were just hearing that the parties are talking past each other. So the most immediate question is why? Plaintiff argues that it's because there's disputed factual allegations, but Justice Tice, as your questions I think indicated, it's more basic than that. It's about what the complaint actually says, what it alleges, and what it doesn't allege. The complaint says only that a loan application was made using plaintiff's phone number and hometown in someone else's name. I heard my brother counsel say that the loan application was made in plaintiff's name. I think he was misspeaking there. Paragraph 18 of their complaint very clearly says the loan application was made in someone else's name. The complaint doesn't say, importantly, that the loan applications used any of plaintiff's sensitive, personal, protected data, such as her social security number. It doesn't say that it used her mailing address. It doesn't say when the applications were made, when plaintiff learned of the applications, whether the applications were
potential harms.
They didn't say when that.
Their data,
they didn't know when that.
For her to represent their
you know when you got made aware of
that. Else triggers a duty. That duty is to,
according to PIPA, to take their identity. Now, I think my brother counsel knows this, so they tried mightily in their briefing to stretch the allegation.
I never heard brother counsel. That's funny. He said my brother counsel. I ain't heard that one. That's nice. I'm gonna have to use that one. I don't think my brother or my sister could. That's kind of weird though. Like, what you mean your brother counsel? That's so weird. I don't know. I never heard that before in my life.
Of their complaint, but they do so far beyond the breaking point. For example, they repeatedly say that the loan applicant used plaintiff's social security number. They say that in their opening brief. No, that doesn't appear anywhere in their complaint. And when we caught their hand in the cookie jar on that in our response brief and called them out for it, they said in their reply, and then here today, well, it's a reasonable inference that her social security number was used. No, it's not. If the person who made out that loan application had plaintiff's social security number and they were attempting to commit fraud, they would have used it in combination with her name, because that's how you commit identity fraud. That's what identity fraud is. So I don't think the plaintiff is asking you to draw reasonable inferences. He's asking you to make unreasonable assumptions based on allegations that do not appear in the complaint, and that
why did they take this case?
Some of the allegations that are actually in the complaint.
They took this case to make it hard for people to file data breach cases, I feel like.
When we take the allegations in the complaint as they are, and as true, respecting the procedural posture of the case.
But to be fair, there's not a lot here, man. There's not a lot here. Not a lot here.
The question presented here is pretty straightforward. whether someone whose sensitive personal information was potentially exposed in a data breach has standing to sue when the only alleged incident of subsequent misuse did not involve their name and did not involve their sensitive information, did not involve private information, only public information was used, and did not involve any protected information. The only information was her phone number and hometown. That's this case, as it's actually pleaded. That's all it is.
Who's got one?
Now, the answer to that question has to be no. Plaintiff doesn't have standing. Plaintiff doesn't have standing because PIPA specifically excludes publicly available information from its definition of sensitive protected information. That's Section 5 of the statute. And because as it's actually pleaded, that's all it is. Now, the answer to that question has to be no. Plaintiff doesn't have standing. Plaintiff doesn't have standing because PIPA specifically excludes publicly available information from its definition of sensitive protected information. That's Section 5 of the statute. And because if plaintiff has standing in a case like this, then the standing doctrine in data breach cases is absolutely meaningless.
I ask you about the propriety of the court's investigation. You raised a number of times the idea about what is private, sensitive, the number of terms of information. And here, the complaint, as you say, indicates that the bank said that they had a loan application in another name, but this plaintiff's phone number and home address, or not home address, city and state. Okay. The court Googled that. This is, again, I'm really back to, Civil Procedure 101. We're looking at the four corners of the complaint. And your argument is this is public information. Was it appropriate for the court to go beyond the complaint and Google to see if, in fact, this information is public or private?
Plaintiff doesn't contest that information is publicly available. And I think it would be unfair of me to criticize the Fifth District for criticizing them because I asked them to do it during the oral argument. I said you can easily verify this. You can pick up, a court can take judicial notice of something. A court can pick up a phone book and look up plaintiff's name. Granted, those are online now, you wouldn't actually physically pick it up, but you know what I mean. There's no question that her phone number and hometown are publicly available information, so I think it is perfectly appropriate for the court to take judicial notice of that, Your Honor. If plaintiff has standing here, then anyone whose personal information is potentially exposed in a data breach will have standing to sue, regardless of whether they suffered an injury in fact, much less an injury that could even plausibly be traced back to a specific breach, going to your question, Justice Cunningham. If that's the standard, we need to be really clear about this. Every single Illinois resident, all 12.8, 12.9 million of us, have standing to sue someone now because we've all had our data exposed in the last few years, probably multiple times. Let me give you just one example that happened while we were briefing this case for you. The background check organization, National Public Data, was breached, reportedly exposing the personal information of billions of people, including the social security numbers of every single American. Do they all have standing? Does the mere fact that the breach happened give them standing? We say no, because without a proper allegation of misuse of sensitive personal information, all we're left with is speculation and fear of future identity fraud. And this court said in Barry, that's not enough for standing.
It kind of sucks that
you
it's
don't
not,
have an
though.
allegation of actual misuse, and we don't here, and that's...
You know how we could get one? If we wrote a law to say if you let somebody data get if you let somebody data get stolen, then you owe them $100,000. We could write that into law. But the reason they don't have an injury is because we don't have a law and it's not obvious. Because common law, you actually got to prove stuff. If you had a statute, all you got to do is break the law.
The nub of the question on standing. All you have is the risk of future misuse. And if that's all you have, this court has said time and time again, that threat needs to be imminent. Now, plaintiff says in her brief, she uses the word imminent a lot. She says that her injury is that, but she doesn't plead any facts that would support that conclusion or make it a reasonable inference. In fact, she pleads the exact opposite. She pleads that studies show that 25% 1 in every 4 data breach notification recipients experience identity fraud. Flip that statistic around. That means 3 out of 4, 75% don't. Can we really call that an imminent threat if the vast majority of people will never experience identity fraud? I don't think so. Time will tell whether that risk materializes into a distinct and palpable injury, going to your question, Justice Holder-White.
How does
But
this
right
case
now,
make
we
it
can't
this far?
simply assume that it will, and that's what plaintiff is asking you to do. On the traceability question, Justice Cunningham, you were asking about this early in my brother counsel's argument.
Stop saying brother counsel.
Traceability requires more than pure speculation. The appellate court's point, Justice Tice, about the publicly available information was that anyone and everyone has access to this. It's out there. It's not protected. That means that there's no set of facts.
His only
that
problem
could
is with the
possibly
brother
be
counsel and how he's
proven,
coming
and this
off.
was the Fifth
It's
District's
too
point.
good, bro.
No set of facts that could possibly
You're
be
too
proven
prepared.
that would tie
You're too
use
correct
of
on the
publicly
issues.
available
You're
information
too nice to your brother counsel.
to any specific data
It makes me
breach.
feel
And
like,
to be
you know,
clear, there is no authority anywhere in the country supporting the
tuck 'em
proposition
away.
that it can be. I'd like to briefly address the duty issue because I think to a certain extent it gets overcomplicated in the briefs. It can be distilled to a really simple question, which is this. Does the court believe that a negligence duty existed in common law before PIPA's 2017 amendment creating a statutory duty to reasonably safeguard sensitive personal information? Now, we say no. We say no because every Illinois court to examine the issue before Flores said no. We say no because every federal court to examine the issue under Illinois law say no. And there I'm referring to decisions like the Seventh Circuit's decision in Trenton, where it actually went out of its way to predict that this court wouldn't recognize a common law duty. The Eighth Circuit's decision in Super Value
This is
case,
superb case
the
references.
Central District of Illinois' decision in the Hy-Vee versus Purdue case, even courts as far afield as the Southern District of New York.
He giving his
in
brother
the
counsel an
Toretto
ass whooping
case
right
said
now.
no. Illinois doesn't have any
And he's going on to other issues. He's past standing already. He didn't just start beating the horse on standing. He's moving on.
such common law duty, and it's not likely to be recognized. The legislature also said no. No, there's no common law.
The justices made the first attorney waste all his time on standing just because they couldn't see it. So he didn't even get to be persuasive about his other issues. That's why they say you're supposed to lead with your most strongest issue. But it's kind of hard to do when there's a threshold issue. A threshold issue meaning unless we can't handle this, we can't handle that. So if you have a stronger point on the second thing, but you got a weak thing on the first thing, you got an issue. You got a real problem in your hands.
Duty. Representative Williams. This isn't in the briefs, and I apologize for that, but it is a matter of public record, and it is in the record in the form of the appellate briefs. Representative Williams said during the floor debate in the House on the 2017 amendment creating the statutory duty, he was asked what the purpose of the amendment was, why it was necessary. And he said because there was then nothing in Illinois law requiring data collectors to reasonably care for sensitive personal information. There he was drawing from a long line of Illinois federal court precedents saying that. So no one.
And I think let's think about that. You give someone your information, like you're deciding to give it up, like negotiate that transaction without having to give up your personal information. I don't know. So how does someone have a duty to take care of something you gave them when that's not really what you bargained for?
Before the Flores court thought this was even a possibility. It also just makes sense that there's no common law duty here. If the legislature was simply enhancing already available common law duties, which is what plaintiffs argue, why would it provide a more restrictive remedy via the Consumer Fraud Act? That doesn't make any sense. There's a reason this court is generally very reluctant to go back and retroactively rewrite the common law after the legislature has passed a law relying on Illinois court jurisprudence saying that that area of the common law, that there's nothing there. And I would respectfully submit that this court needs to be really, really careful with this question on duty. Data breaches often involve hundreds of thousands, millions, sometimes.
His client is weakest on duty because they didn't even have a system to say what was taken and this and that. Well, I don't know. I don't really know the facts of the case that well.
Billions of people creating new duties, expanding remedies, when dealing with issues on that scale, that is a public policy question that's best left to the legislature. And that's not just me saying that. This court has said that time and time again. The legislature is in the best position to make those kinds of public policy determinations, especially when dealing with issues expanding civil liability. And this court has been reluctant, I think rightfully, to second guess those legislative policy determinations and to expand legislative created remedies by judicial decree. The court should.
If we agree with you on standing, do we have to reach this issue of whether or not there's a common law duty for negligence?
You don't have to, Your Honor, if you agree with us on standing. If you don't agree with us on standing, then I believe you would be required to. Just to finish out the last point, and then I'll wrap up. This court has said, and if I may quote the court, I don't like reading, but it has said that it tries to avoid delving in what it is called judicial metaphysics by saying that the legislature intended to provide a remedy in addition to a common law remedy which existed but has not yet been declared by the courts. The court said that in the Cunningham case.
Makes sense.
That is exactly what the plaintiffs are asking you to do here. Engage in those kinds of judicial metaphysics by rewriting the common law after the fact. The PIPA amendment here is very carefully balanced by the legislature. They deserve some credit. They were balancing the need for victims of identity theft and identity fraud to have recourse against the fact that most of the time, even according to plaintiffs' own allegations, the injury is only speculative. And even then, when there are some, it's only de minimis. And we need to remember that victims of identity theft, they're not left without a remedy here if they experience actual misuse of their sensitive protected information. They have the Consumer Fraud Act via PIPA's 2017 amendment if they can show actual damages, which begs the question, why are plaintiffs here so desperate to have their negligence claim? And I'd respectfully suggest it's because they know plaintiff doesn't have any actual damages. If plaintiff is unsatisfied with that remedy, she can go across the street to the legislature. That's where her...
This nigga, what you running for, my G? What are you running for, my G? What is the name? Baldoni? What's the homie name, bro? Because he going hard in the paint. He's going hard in the paint. 34, 36 is where you got to come back to.
We're not alleging that every company ever has to protect every piece of data that they have against any data breach or disclosure whatsoever. And
Counsel, would you bring your remarks to a close?
Oh, I'm so sorry. Thank you, Your Honors, and I'll let defense counsel speak.
Thank you very much. Counsel for the appellate.
Madam Chief Justice, and may it please the court, John Amarillo for defendant Christy Clinic. I think it's...
He's a smart guy.
If plaintiff is unsatisfied with that remedy...
Go across the street to the legislature.
She can go across the street to the legislature. That's where her redress is. It shouldn't be had in this courtroom. Thank you.
Thank you very much, Counsel. Counsel in reply.
I just want to make one point about duty, and then I want to move back to standing briefly. With respect to duty, I encourage this court to look at Dittman versus UPMC. It's a case out of the Pennsylvania Supreme Court where this exact question was posed to that court, whether or not a duty existed in the common law. The court said there that we're not in the Supreme Court. To duty, I encourage this court to look at Dittman versus UPMC. It's a case out of the Pennsylvania Supreme Court.
Why would he care? Why would we care about Pennsylvania common law, counselor?
Where this exact question was posed to that court, whether or not a duty existed in the common law. The court said there that we're not creating a new duty. What we're doing is applying a general negligence standard to the defendant. The duty there is the exact duty that we allege here, which is a duty not to take foreseeable acts that create a foreseeable risk of harm to somebody else. That's a duty this court has recognized in Simpkins, in Brokenberger, and other cases, and this court has said it's a well-established duty. I also encourage this court to look at Valeria. It's a first district case. And what Valeria said, I think very intelligently, is you have to ask where the duty arises from. If it arises in statute only, then there's no
It
common law
doesn't.
duty. And you
That's a
can't-
great That's a great point. Because at the end, whether there's a statute or not, you can't do what you want to do, regardless of how it affects people around you.
bring the common law claims. The statute overrides those.
That's a great point.
If it arises in the common law, then even though there's a statute that may provide a different claim, there's still a common law claim. This is a common law duty that this court has held as well established. And just like it's been held in Pennsylvania, even though its lower courts all agreed with defendant's position that this seemed like a new duty, the court there said this is not a new duty, it's a traditional duty being applied to a novel circumstance. And I think the court should adopt the same. Moving back to standing, I think defendant is trying to weaponize an informational disadvantage that plaintiff has at this point. Defendant says everybody will have standing in a case like this. Every data breach victim, merely by getting a notice, is going to have standing. That's not true. We have here something different. We have, soon after this data breach, information being misused. We acknowledge it's non-sensitive. We acknowledge it would be great if we knew a social security number was impacted. We don't know all that information that was used on those fraudulent loan applications. And the bank didn't tell the plaintiff. We don't know everything that happened in the data breach either. We only know what the defendant told us, and there's a lot of things they don't know about what happened in their data breach. But what we do know is we have a target by hackers in a healthcare entity that is a frequent target specifically because it has a large volume of very sensitive data that can be used for the exact purpose that we saw after the data breach, which is financial fraud and other fraud like identity theft, medical fraud, or insurance fraud. So exactly what you would expect after a data breach if the hacker targeted and took the data is happening here. Where is
the insurance fraud and medical fraud?
I didn't mean in this case. I mean that's what you would expect from a healthcare entity being targeted and the data being taken. Financial fraud is one of the things that happens even after these healthcare data breaches because, as the defendant has acknowledged, social security numbers being breached can be used to open up these potential loan accounts or to apply for a loan. So we don't know. We don't know at this stage. But what we do know is enough to reasonably infer that there's a connection here. And that's enough to get us in the door and take discovery and figure out whether or not we're right. We have a factual disagreement with the defendants. That's okay. That's going to exist throughout the litigation. They're going to argue their view of the breach. We're going to argue ours. But we have enough here to get in the door and to see whose view is right. Maybe defendants will prevail. Maybe at the end we will. But I think if you brought a reasonable jury here before the court and asked them, what's more likely here? A data breach happens. Soon after, there's a series of fraudulent loan applications coming out using the same data in the data breach. Did that cause the fraud? Or did somebody pick a name out of a phone book that contains millions of names and it happened to be Rebecca Petta? I think a reasonable jury could find
the name
our
wasn't
view is
used.
right. And if a reasonable jury could find our view is right, given the facts we already know, then we've alleged enough to reasonably infer.
In his powerful statement, no one picked her number got picked out. Or maybe that's what he meant, but like, what did he say?
That here agreement with the defendants. That's okay. That's going to exist throughout the litigation. They're going to argue their view of the breach. We're going to argue ours. But we have enough here to get in the door and to see whose view is right. Maybe defendants will prevail. Maybe at the end we will. But I think if you brought a reasonable jury here before the court and asked them, what's more likely here? A data breach happens. Soon after, there's a series of fraudulent loan applications coming out using.
He got it. He mixed this up too. He's supposed to say fraudulent.
The same data in the data breach. Did that cause the fraud? Or did somebody pick a name out of a phone book that contains millions of names and it happened to be Rebecca Petta? I think a reasonable jury could find our view is right. And if a reasonable jury could find our view is right, given the facts we already know, then we've alleged enough to reasonably infer that plaintiff has alleged enough to have standing.
Yeah.
And unless the court has any other questions,
if you say it like that, you'll win a summary judgment.
Thank you so much, counsel.
Thank you.
This case, agenda number 7, number 130337, Rebecca Petta versus Christie Business Holding Company, will be taken under advisement. Thank you very much for your argument.
Let's see if we can find it on the. I want to see, when are some of these dates from? I want to see opinions. Oh, so these are fresh off the presses. The White Sox. Oh, this is kind of juicy. Dang, this is kind of juicy. That's kind of I gotta say this one. This one's kind of juicy. That one's kind of juicy. Someone got fired for being gay at the Chicago White Sox, apparently, according to the allegations. What is this about? What does it have to do with BMO Harris Bank? As all for the state of so someone the state is being sued. This should be interesting just because someone the state is getting sued. Look how many cases. That's not just Supreme Court cases. Man, see. I just wanted the Supreme Court. Yeah, I'm like, I know the Supreme Court ain't deciding this many cases. Oh, they decided it. Wait, how soon after hearing arguments did they decide it? So they heard arguments. Brief. Appellee Amarillo filed his 8/24. Golly, it took a minute to get before the court. Okay, so I'm trying to see where's the oral arguments page. Opinions and rules, and this is our Supreme Court's oral arguments. Okay, so we'll just put the opinions on this side so I don't get confused, and then here we have the briefs, right? This is just the docket. Okay. So they argued oral arguments on November of last year. The opinion was released on January of this year. Let's see. Let's see what the court decided. Rebecca Petta. Opinion. The plaintiff, Rebecca Petta, filed a class action complaint. Whoop de whoop de whoop. The complaint alleged that negative whoop de whoop de whoop. On appeal, the affirmed the trial court's holding lack standing for the reasons that follow. We affirm the judgment of the appellate court. You ain't got standing. It was obvious. Let's see what else they. Let's get to the juicy bits of law, isn't it? I don't want background, my Jeezy. To call. What does it mean to call? That means to withhold their dockets so as to preserve for consideration only those disputes which are truly adversarial and capable of resolution by judicial decision. Greer versus United Housing Department Authority, 1988, my birth year. So basically, don't come here if you don't really got a problem, shorty. This is what you need for standing in Illinois. This is what you need for standing. All right. Now I'm gonna take that down because I'm putting this right in CF Pro. I'm putting that right in CF Pro. I'm putting that right in CF Pro. Once I go through my and organize myself, because that's what we call a rule, a statement of the law. More precisely, the claim injury, whether actual or threatened, must be distinct and palpable. And this all is coming from Greer. Fairly traceable to defendant's actions and substantially likely to prevent a redress by the grant. So they got even if he did hurt you, it has to be substantially likely to be prevented or redressed by the grant of relief requested. So now they're just letting her know why she lost. So she lost. Furthermore, as the appellate court observed, the unsuccessful loan application cannot be said to be fairly traceable to any of Christie's alleged misconduct, given the fact that the information used in loan applications, her phone number and city, could be found in the publicly available phone directory. Thus, as the appellate court determined, Petta's allegation regarding the loan application is purely speculative. Purely speculative. They didn't acknowledge the timing. You got to plead the timing, my G. Because they didn't mention the timing. Even though that was the big part of Petta's case, is that the timing of when, because that public information had been available. That information had been available. But and after the breach, now the application starting to come in, but they didn't plead that. You gotta plead it. I don't know why that wasn't pled. I really don't. But you gotta plead it. Pleadings matter. So yeah, so that was the Petta case. I want to do one more. I want to pick a good one though. I want to actually let's pick one where we have a let's see what these is. Because I want it to be. Because I want to see the oral argument and I also want to see the opinion. Let me go pee first. let's see. See what else? I need a better chair. I might bring my. Should I bring one? I'm get them back. So I want to get. So this is probably the best way to. That was flipping. So I need to come look up. I look up. So let's do. Let's go just purely off name craziness. Let's go this one. Kokar. Let's see if we can find Kokar. Boom. Then we're gonna take it here. Then take it here. Alhamdulillah. Okay, here we go. Oh, all we got is appellant's brief. One-sided argument. What does that mean? What's going on here? So Kokar, as the county clerk, the trial court lacks special statutory jurisdiction over petitions, election contests, due to petitioner's failure to file a. That was kind of boring. We're gonna have to keep. We got to keep moving. We got to keep moving for stuff. Okay, we got some Amosai brief in here too. Oh, so we did. This is a hotly contested issue we have here. Let's see let's see who filed the Amosai brief. So the Illinois Department of Labor in support of a reversal. What else we have? And then we have Illinois Chamber of Commerce, Chicagoland Chamber of Commerce, and Illinois Manufacturers Association. So the union against the city. Let's see. What are these cases about? Let's see. It's an employment law case, bruh. Whether exclusion from the regular rate of pay set forth in. Yeah, I don't want to do employment law, my G. Sorry, I'm learning what kind of stuff I like. I don't wanna do it. I don't wanna do it. I want like a business case. What is this? Oh, this is a custody case. I don't know if I want to deal with that either. Walker versus Chastain. Who? So it's about fees. What kind of law do we're probably looking at? State law? What kind of the Constitution? Yeah. Interesting. Don't know if I'm quite interested in that one either. People v. Morgan. Yo. Russell wrongful death case. What is up with this one? Oh, this is a defamation, so this might be good. Let's see if this is orally argued. This was Gloriso versus Sun-Times Media Holdings. Boom, we got video. We got action. Now we'll just go find their... Here it is right here. Who do we have an amicus brief from? We have an amicus brief from... the Reporters Committee for Freedom of the Press and other... Let's see what the appellant said, because now we're gonna get into this, John. We're gonna get into this, John. We're gonna get into this, John. An hour long. We're gonna get into this, John. The underlying action was brought by Mauro Gloriso, former executive director of Cook County Property Tax Appeal So the Cook County Property Tax Appeal Board, that their former ED sued the Sun Time Media Holdings Company and Timothy Novak, collectively the Sun Times, or defendants, for defamation based upon 2 newspaper articles that reported on Governor Pritzker's promise to investigate political influence involving the tax appeal by Trump Tower. So this involves promise to investigate political influence involving the tax appeal by Trump Tower in Chicago. So there was a tax appeal for Trump Tower. Sometimes appeals from the September First District Appellate Court, Mauricio, affirming the Circuit Court's order and denying defendant's special motion to dismiss under Illinois Citizens Participation Act and request reversal in accordance with. So the Sun Times appealing because on September 18th of 2023, the appellate court affirmed the city court's denying defendant's special motion to dismiss. So they got a motion to dismiss denied and request reversal in accordance with the First Amendment, U.S. common law, and with Justice Hyman's dissent requesting clarification and correction of the majority's interpretation of the. Who's the majority, my Jeezy? Of course, so the lower court juror asked for reversal, requesting clarification and correction of the majority's interpretation of the I. Oh, so dang! So Buddy right here was like, "Hey, y'all didn't even y'all didn't even read the law right, fama ding dong." So why don't we get the Supreme Court to send it right bone? Is he a Republican? Well, he's probably not, but. So he basically saying that they may not have interpreted the Illinois Citizens Participation Act. Statement of the issues. Whether the appellant court erroneously required news media defendants to prove under the ISP that a public official is both meritless. So that's a burden of proof question. Whether the ICPS protects news reporting relating to whether the uncontested record demonstrated that an investigative official's litigation against a daily newspaper is ended. So they're trying to whether the uncontested record demonstrated that an investigated official's litigation against a daily. So an official that had been investigated, he sued the newspaper, and the reporter was a strategic lawsuit. Whether the First Amendment and Illinois law permit political appointees to sue for defamation based on potential implications a reader or listener may draw. So implication, they may not have said he did it. Whether the law of actual malice, special damage to innocent, rendered this defamation case about. So this is good. So I'm really looking forward to this. To this part. This is gonna be the last one I do. So we got some juicy. So all right. So all these issues, I'll sum them up for you guys. So this is a defamation lawsuit. We got a public official in Illinois, let's look up a little bit of the details behind this case a little bit as well. So this is what we'll do. We'll do this name, and then we do Trump Tower, and then we'll do Pritzker. See what we get. Pritzker dumps official who pushed for Trump to get $1 million refund on Chicago Towers taxes. So this guy, Mauro Gloricio, a Westchester Republican, the governor appointed to head. So he gave Trump a sweetheart deal, basically. Yo, no, look at this. So the agency's handling of Trump tax appeal, which was filed by Chicago law firm of Edward M. Burke. Oh my goodness! So from what it says down here, like this guy basically, a law firm of a elected official that's been accused of corruption, Edward M. Burke, filed a tax appeal for Trump. So Trump thought he paid too much in towers. Trump Tower, which I'm not sure is even owned by Trump or not. Oh, so that's Edmund Burke. That's not even Gloricio. That's not even That's not this guy. That's not this guy. That's Edwin M. Burke in the picture, which is an old school kind of corrupt, get stuff done kind of guy, allegedly. Okay, so now I want a picture of this guy though. Let's get a picture of the guy who's actually. Oh my goodness! Don't tell me. Looks like a good old boy. I'm just kidding. I got to stop talking if I don't have a career anymore. Okay, so that's the guy who's suing the Sun-Times for alleging that he took a bribe in order to make sure Trump got his $1 million tax credit, or Trump Tower. I'm not sure if Trump Tower and Trump are the same entity anymore. You get me? Yeah, get me. Okay, so now we're coming back here. So all right, so now let's come back to the issues. Okay. So whether the appellate court erroneously required news media defendants to, so should the court have required the news to prove under the ice maze that the public official defecated is both? So do they have to prove? So the news media got sued, and then the lower court made them prove that the other guy's case didn't have any point. That doesn't seem right. Whether the Defamation Act protects news reporting related to official investigations of unelected political appointees. Whether the Defamation Act protects news reporting relating to official investigation. Okay, I guess that's a technical question. Remember, the act is called Illinois Citizen Participation Act. Participation probably in, so I guess unelected matters there. Whether the uncontested record, so whether this is a slap, whether this guy is trying to use intimidation to, well, that's kind of what is it saying exactly? Whether uncontested records demonstrated that an investigated official's litigation against a daily newspaper and was a strategic, yeah, they're trying to say, did he use a slap lawsuit, which is strategic lawsuit against public participation, meaning these news people tried to do a story, and since they did a story, you sue them, so that's going to discourage other people in the future from participating in public discourse, which is not good. We want more people talking about how they see the truth, so we can kind of get an understanding of maybe what truth really is, or what's really going on. Fourth, whether the First Amendment and Illinois law permits political appointees to sue for defamation based on potential implication. This is going to be a hard case for I think that Clariso is going to lose. I think he's going to lose, but I do want to watch some of the case. So Just again, really quickly, we have a defamation case in front of us. They're going to be talking about defamation. And it's about a public official who was appointed, not elected. He's alleged to have pushed through a tax appeal credit. But the newspaper wrote about that, about how he may have done that. And he's saying, hey, that's defamation. You can't say that I'm a corrupt official. Like, that's not cool. Like, I'm a public servant. I take my position seriously. How dare you say that I gave Trump Tower $1 million tax credit, even though some of the news articles said that the staff below him said that the credit was unfounded, but he pushed it through anyway. Maybe that's what the news article talked about. But yeah, they're getting sued, and that article is still on the website. So I think they're getting sued about this article that's still on the website. Let's see if they mention an October 9th, an October 9th article. Let's see. I want to see. Are they going to mention the actual newspaper? Yeah. All right. So, but also, what seems to be very at issue is this act, the Illinois Citizens Participation Act. That seems to be very, very much part of this. So let's dig into these arguments, and then let's see who won the case.
Addendum number 16, number 130137, Haro Glorioso versus Sun Times Media Holdings, LLC. Counsel for the appellant, are you prepared to proceed?
Let me go get a refreshment, sorry. I win. Logic wins. Let's get started. Defamation case. She looks so invested back there. Poor thing.
Good morning, Your Honors.
Good morning.
Thank you, gentlemen. My name is Damon Dunn. I
Esquire.
represent the Chicago Sun-Times
Unless you're not.
and Timothy Novak. Thank you for the opportunity today to address these important questions regarding our fundamental freedoms, which are secured by the First Amendment Press Clause and by the Illinois Citizens Participation Act. We would like to you to heed Justice Hyman's call for correction and clarification of the law in these respects, because the majority's opinion derogates those protections to disadvantage reporting on government investigations. I believe, ironically, any examination of the contours of the Citizens Participation Act, which I'll just call the Act, should begin at the end with Section 30, where the legislature says that it shall be construed liberally to effectuate its purposes and intent fully. Instead, we join Justice Hyman in his analysis that actually the majority encourages public officials to slap down inquisitive reporters.
Are you asking this court to modify its opinion in Sandholm?
Out of the box, Your Honor, we believe that
Not familiar with that opinion. Probably another defamation case to do with the act.
we prevail under the proper reading of Sandholm, which is essentially what Justice Hyman says. We think there are three paths, actually, before this court. And though I am somewhat constrained as a litigant to litigate within the boundaries of the First District's precedent, Justice Hyman obviously is a little less constrained. You are not. And for reasons that I would go into, I would suggest the first path is you can apply Sandholm, as the appellate court did in the Garral case, and we win. We win because there is truth, there's no actual malice, there's no special damages, and the recklessness test could easily be met by meritless. And because
Counsel, under Sandholm, what is your initial burden in this case?
under Sandholm, my initial burden, and I want to get to your question, my initial burden under Sandholm in a non-traditional slap would be to show that the plaintiff's case is not genuine. Instead, in this case, out of the box, the majority made us prove that our speech wasn't genuine. But let me get to your question. This is a traditional slap. Sandholm was discussing a non-traditional slap. I believe that this is exactly the kind of slap that the Texas Supreme Court identified this year, which is quoted in our reply brief, as exactly the kind of lawsuit by a government official against a reporter in response to a critical news story that we all can agree has been subjected to early testing on its merits and early appeals. I believe this court should look to Right Development versus Walsh, which also ironically involved a Sun-Times story published in the Pioneer Press. In that case, the court said that this act plainly includes statements to a news reporter on public concerns, because that's expressly encompassed talking to the electorate.
So you I think, very basically said here that the traditional, or I'm not sure you said it's not traditional, but the case, for example, in Sandholm, which involved a group of people making statements about a public school teacher, coach. That what distinguishes this case is because the defendant in this case is the Sun-Times and a reporter. Is that the key difference between the analysis in Sandholm and what we have here?
Well, that's clearly a difference. But perhaps if we took Walsh literally, the key difference is the statements to the reporter are from Governor Pritzker. That's what was published. They didn't publish on an anonymous tip. They filed FOIA requests. They sought comment. They went all the way to the governor's office. The governor, through his spokesperson, gave us two statements. One, he promised to get to the bottom of any allegations of political bias driving that decision, and he promised, or he requested PTAB not to act until then. So I
think we're first concerned about what's the proper analysis for any kind of anti-SLAPP motion. Before we get there, certainly what the court said in Sandholm was trying to understand the statute. And it says the act's intent to strike a balance recognizes that a solution to the problem of SLAPPs must not compromise either the defendant's constitutional right of free speech and petition or plaintiff's constitutional right of access to the courts to seek a remedy for a damaged reputation. So the Sandholm court said there's a balance here that has to be struck. Do you agree with that?
I agree that there's balance, but I also suggest that Sandholm put the balance in the wrong place because the act elevates, it's not supposed to be equal. The act elevates speech. In the Walsh case, on very similar facts to this case.
Well, counsel, back to what Justice Overstreet asked. Are you suggesting that we should modify Sandholm?
I'm suggesting you should, but I'm also saying that that's not necessary to decide the Sun-Times case. And if the court wishes to address Sandholm, I am more than prepared to do it. I don't want to do it to disadvantage my client by attempting to overreach and saying we depend on you changing the Sandholm decision. That we don't have to argue.
Well, they don't mention it now.
But I do believe, on behalf not so much as the Sun-Times, but as the Sun-Times as an agent for the people and the citizens of Illinois, I believe Sandholm is incorrectly applied in this context. It's incorrectly applied in most contexts with investigative reporting. If we look at the act, we should do what Walsh does. Walsh, this court said, this is protected speech. Statement to the reporter.
FYI, it's never good to tell the court that they have to overturn some of their past decisions to agree with you.
On public affairs. We default then to Section 20C of the Act. We look at the plaintiff and we say, do you have clear and convincing evidence that you're not showing speech, that this speech isn't genuine? And in Walsh, they looked at two things: knowledge and was it a false factual statement? And in both cases, knowledge and a false factual statement, the court said plaintiff failed his burden. End of case. Why do we make judges in obvious slaps jump through 3, 4, with the majority, maybe 5 or 6 hoops? That's obviously not what the legislature intended when it asked for a decision in 90 days after notice. It expected that if you're going to file speech that on its face chills, talking about how we are governed in this state, you as the plaintiff, if challenged, need to put up or shut up in 90 days.
What do you mean by that?
I mean,
let's be real clear. So you're not making a broad statement that every defamation case where the statement by the defendant has some kind of public interest is by definition a slap suit. You're not saying that every single, or are you saying every single lawsuit of a plaintiff against a defendant who speaks to the public interest is automatically a slap suit? Is that what you're saying? How broadly are you drawing this?
I'm drawing it.
Or are you saying is by the defamation case where the statement by the defendant has some kind of public interest is by definition a slap suit. You're not saying that every single, or are you saying every single lawsuit of a plaintiff against a defendant who speaks to the public interest is automatically a slap suit? Is that what you're saying? How broadly are you drawing this?
I'm drawing it, first of all, broadly enough that my client wins. But for the court's purpose, I believe that any time that we have a public official...
Don't be cheeky, bro. Answer the question. Don't be cheeky. Keep it a buck.
...suing over a critical news story, we're in traditional slap territory. Now, to take over a critical news story, that we have a public official suing over a critical news story, we're in traditional slap territory. Now, to take...
So no public official can ever sue for defamation?
No. I think that where Sandholm misplaced the this placed its emphasis in its analysis, because remember, Sandholm didn't come up with any challenge to the merits. The parents squabbled with the basketball coach. The court said at the end, go back and find out if this case has got merit.
Counsel, can you walk us through the analysis that we should undertake in this matter? Where do we start? Who has the burden? How do we look at this?
I gladly do that. Do you want me to do it in this case, or do you want me to do it as a broader perspective?
In this case.
In this case, I would say, we look at Sandholm. Sandholm says, this is statements to a news reporter on public concerns addressed to the electorate. Even the majority agreed that this was within the SLAPP language. The majority endorsed Ryan.
That's not what she just said.
They just came up with
she
this
said go from
carve-out
burdens too
for unelected public officials who get removed, which, as Justice Hyman said, is beside the point because it doesn't address the reform aspects of finding out what happened.
So the first step is to determine whether or not it comes within the purview of Sandholm.
Is it a traditional SLAPP? I think Sandholm on its face is, how do we screen for the non-traditional SLAPPs? How do we screen for the cases that we don't know if it's a SLAPP or not? How do we know if this is just a squabble between parents and a high school basketball coach? That's when Sandholm comes into play.
So your position is there is no dispute that this is a SLAPP here?
Well, obviously the majority felt that you can't slap an unelected official, but I think Section 10 of the Act says clearly to the contrary. Officials and employees are covered. So no, I think this is clearly a SLAPP, Your Honor.
And when I say no dispute, I'm referring to between the sides in this case, not the appellate court. I'm saying, is there a dispute on that issue?
I can't speak for Mr. Zizek. I think there's no dispute that the whistleblower said Moria Glosso gave a directive that they staff complied with. No dispute that there was an investigation. No dispute that the Sun-Times took no outcome. But I also think that under Walsh, there can be no dispute that this is a SLAPP.
Okay, so
It's
first
clearly
step,
within the purview of
determine whether or
Walsh.
not it's a SLAPP, and whose burden is that? And then where do we go from there?
Under the statute, you go directly to the plaintiff. The plaintiff has the opportunity, if you're going to file a complaint in this arena, challenging public speech, Section 20 puts the burden on the plaintiff. And that's very easy. I mean, if you're a circuit court judge, why are you trying to figure out what people's motives are? And why are you trying to decide what recklessness might be under these unworkable and subjective tests? Why not just go to the plaintiff and say, hey, do you have, as in Walsh, do you have evidence that this statement was intentionally false? File an affidavit. Take some discovery if you've got good cause, which I don't think there was in this case. But put up or shut up. We have 90 days. Let's make a decision. The legislature wasn't so much concerned, I think, with immunity. I read the statute more as placing the burden of proof early on the plaintiff in these cases. It's more of a procedural statute more than a substantive statute. Substantive, yes, that would say, and I think some of the court's questions seem to be directed at this, or are we going to immunize this entire spectrum of speech? I don't think the statute does that. I don't think that was what the legislature intended. I think the legislature intended is when we get into this particular arena, we want an early test and maybe a slap on the wrist if you filed a case that maybe lacked candor or maybe omitted the real facts. That's what the legislature wanted. And, to be fair, you're going to have to, as a plaintiff, meet these tests eventually under the First Amendment. You're going to have to come up with clear and convincing evidence of actual malice in this case. You can't just skate by not filing an affidavit. I mean, our precedents say, don't file the counter affidavit, fatal to your case.
What can I say? The SLAPP statute is, I would suggest, somewhat unusual in that usually we, in considering whether to dismiss a complaint, the balance usually is whether the complaint states a cause of action or whether there's affirmative matter, a defense to defeat a recognized cause of action. But here, the statute seems to require some inquiry into the intent on the part of the plaintiff. Why did the plaintiff file this suit? I think that's, to me, that's kind of the difficult part. How does a court determine intent, whether or not the purpose for the lawsuit was in fact retaliatory, was to chill free speech, or was it in fact to pursue a constitutional right to damages for damage to one's reputation? I mean, usually we don't talk about intent, dismissing a case because of intent. So how do we sort that out? How does
She really spelled it out right there. She really spelled it out. Like, anti-slap lawsuit. Yeah, you can't say things better than they were just said.
the court sort that out? It seems to me that's what Sandholm was trying to figure out.
I think Sandholm,
In fact, to pursue a constitutional right to damages for determine intent, whether or not the purpose for the lawsuit was in fact retaliatory.
Yeah. Is it a retaliation, or or were you really defamed? They posted a story about you. Are you really mad at them? Are you mad at them, and are you just retaking action, or do you really think that they shouldn't? That it's not true? And like, that's a very fine line.
Is to chill free speech, or to damages for damage to one's reputation. I mean, usually we don't talk about intent, dismissing a case because of intent. So how do we sort that out? How does a court sort that out? It seems to me that's what Sandholm was trying to figure out.
I think Sandholm was only doing that because we had multiple parents attacking a high school coach. I don't think Walsh was concerned with intent at all. I don't think Ryan was concerned with the intent of a newspaper expose about judges. I don't even think the majority was particularly concerned about intent. But I would suggest that intent is the wrong place to put the court's emphasis. If you want to actually examine this, you should look what Justice Hyman says about merit. If it's meritless, then obviously the intent shouldn't have been there. Meritless should trump intent. It's objective. We don't have to get into attorney-client privilege as to whether something's reckless or not. We just make an objective test. Do we have some?
So basically, what he's saying is that, like, when it comes to the merits, like, all right, so we're trying to decide whether what you're doing is retaliation. Is your lawsuit retaliating because you don't like what someone wrote about you? Or are you suing because what they wrote about you is defamation, is a lie? So they're saying that if you look to the merits, which shows whether it was the truth or not, if it's the truth, he's saying the person knows that they wasn't trying to defame you because it's true. You can't say you're slandering me if you actually did those things, because you're not protected from. If you did them in private, maybe you may have a privacy claim, but a defense to defamation is that it's true, and because no one's lying about you. The issue is if someone lies about you in some particular cases. But if you actually did that and you did it in public, forget about it. Like, now it's newsworthy because now we have to talk about it because you did something in public that people want to talk about, and we have free speech in this country. So what he's saying is that you did something and it was of public, and you admitted you did. You admitted that the guy admitted that you gave the order to give the tax credit. Now you're suing because people are saying, hey, why he gave this tax credit in a shady way, but you admitted that you gave it, so it may not have been in a shady way. So, and that's why they're litigating all the way up to the Supreme Court. But yeah, so that's a little bit of summary of what I'm getting so far. We still got a lot to go in this video.
Some evidence that this was a knowing lie. Do you? Give it to us, and the case can go forward. Don't give it to us, and we do what the legislature says. We terminate the case. The Massachusetts Supreme Court.
So should we consider whether or not the suit is brought in order to seek personal damages or harm to reputation versus whether or not it's brought to speak and participate in government? Should we even be engaging in that type of analysis?
I don't think you should, Your Honor. I don't see how you could possibly. I don't see how demigods could figure that out in 90 days.
I didn't understand her question. Let me go back and try to
do what the
understand
legislature says. We terminate the case. The Massachusetts Supreme
So
Court.
should we consider whether or not the suit is brought in order to seek personal damages or harm to reputation versus whether or not it's brought to speak and participate in government? Should we even be engaging in that type of analysis?
I don't think you should, Your Honor. I don't see how you could possibly, I don't see how demigods could figure that out in 90 days. I don't believe that the legislature intended that at all. They intended to put the burden directly on in 20C on the plaintiff who files a case that chills speech about public affairs. That's what they decided to do. I think that it's fair. That determination has to be made eventually,
So
instead
how
of
would the
3 years
plaintiff-
later.
How would the plaintiff do that? You said affidavit. What other method would the plaintiff be able to use to convincingly meet his burden of proof at that stage of the proceedings?
Well, in this case, if the final report of the Ethics Commission said in re Wagoner instead of in re Glorioso, he might have submitted it, but he didn't, because it says in re Glorioso. And it says that he was fired not because of anything we wrote, but because he violated the Illinois Records Act, and that's why they barred him from employment. If he had a OEG whistleblower complaint attached to his complaint, which he did not, forced us to put it in, and it didn't say that he told the chief AHA to switch the opinions were switched, and everybody acted according to his directives, well, if it didn't say that, then he could put it in. And he could say, well, you read it, and you said, he pushed and pressured instead of directed. Well, frankly, I think told and directive is worse, but there's ways to do that. He tried to do it in Walsh. He took a deposition. He argued that the defendant was lying. This court looked at it and said, no, actually, it all turned out to be true. He wasn't lying. Case dismissed. In the Massachusetts Supreme Court, from which Sandholm took this analysis, took its inspiration, just this year in Bristol Asphalt, backed away from the whole thing. Said it strays from the statutory language, says it gets too tied up in subjective motives, said it leads to inconsistent results. And we don't need to look any farther than the Garal case in the First District, and this case, to find out how the results can differ on questions that really have nothing to do with the slap. So I believe that if you wish to retain Sandholm and use this Sandholm screening mechanism for the cases that just aren't obviously a slap, a squabble about a high school basketball coach's treatment of his players, instead of the governor promising to get to the bottom of what's happening in the PTAB.
No, it's the report of that.
Well, yes, we reported it, and that's what Sandholm, exactly what happened in Sandholm. The fella comes out of the meeting, talks to the reporter, the Supreme Court says it's enough. In this case, just remember, we did not go on the tip. If you look at the story, it's about what the governor said. We had publication for months to get that confirmation. That's what the story was about. But what does the governor investigate? Well, we had to say something. So we said, this is what he's investigating. And of course, we now know.
What do you mean you had to say something? Well, you can't say something that is malicious and with intent, knowing it's not truthful. Like, so you can't you have to say something, but you still can't say that without being sued.
The governor was talking about the plaintiff. The governor investigated the plaintiff, and the story was true. I think actually it's an easy case under Walsh, and it's not that difficult a case under Sandholm. But I believe all of your questions really, in a way, are pointing up the problem with Sandholm. Sandholm is asking you to probe people's minds. Sandholm is asking if you're going to use this recklessness test.
I gotta look it up. I'm sorry. Sandholm. For a defendant to prevail under the anti-SLAPP statute, they must show that the plaintiff's claim is based on, relates to, or is in response to protected first-class rights, meaning your free speech. So his claim is related to your free speech, and his claim is meritless and was filed solely to interfere with, retaliate against, or prevent you exercising your free speech. So it has to be relating to your free speech, meaning First Amendment rights. I mean, if you're doing something that's not First Amendment protected, it may not apply. Because if you don't have a right to do something, that's not what we're talking about. The court emphasized that. I had a book in my nose. The court emphasized that the test requires looking at plaintiff's intent in bringing the suit. Intent. So that's what they were discussing a lot in the oral arguments, the intent. If the plaintiff has a genuine claim, seek relief for damages, the case should survive even if it arose from protected act. If the plaintiff has a genuine claim, seeking relief for damages. So if someone says, hey, that's a SLAPP lawsuit, if you can show that you have a genuine claim seeking release, the case should survive even if it arose from protected activities. Okay. Because here, remember, it was saying that, but it's not meritless, so it fails the second step. Has a genuine claim seeking. So if a reporter has a protected activity to report, then you can still get hit with a good counter lawsuit if you still harm someone else. The statute should not be used to cut off potentially valid claims that happen to arise from protected free speech or petitioning activities. This case significantly narrowed the scope of Illinois anti-SLAPP statute by making it harder for defendants to dismiss cases. So basically, they're saying this case made people required to prove that the lawsuit was retaliatory rather than legitimate, proven intent. So yeah, that doesn't seem super intuitive. Well, if you're saying that the suit should be dismissed just because it's a retaliation, then I guess protecting plaintiffs with genuine claims even when. So now I understand more what they're saying about Sandholm. Sandholm was basically. You basically got to know someone is retaliating.
Damnance and timing? How can you prove that without invading the attorney-client privilege? How can you get into the reporter's motives without getting into the reporter's privilege? I could file...
More than breadcrumbs. Try to explain that by saying the way to do that is the reporter, the defendant has to come forward and say, this was meritless. And if it was meritless, then the only intent could possibly would be retaliation. Isn't that how Sandholm sets up the analysis?
I don't know if that's how Sandholm sets up the analysis, because it doesn't, I know my time is up, it doesn't really have a meritless retaliatory test in it. Meritless and retaliatory are shown up as descriptions of SLAPPs. Sometimes we see them two together separated by comma. Sometimes we see meritless without any reference to retaliatory. I'm not really sure as descriptions of SLAPPs. Sometimes we see them two together separated by doesn't really have a meritless retaliatory test in it. Meritless and retaliatory are shown up as descriptions of SLAPPs. Sometimes we see them two together separated by comma.
He would know better than
meritless without any reference to retaliatory. I'm not
also
really sure
advocating a
that
certain side
Sandholm has a test,
so he's biased,
other than
maybe towards ultimate
to
truth.
have, let's examine whatever the plaintiff's motives were. And in this case, we're examining the defendant's motives, so we're not even in the Sandholm landscape. That's why I believe, in fact, frankly, it's all clear. That's why I'm standing here. The court wants to know what to do with Sandholm. Amici have a path for Sandholm. Justice Hyman has maybe a shorter path, one that preserves Sandholm as much as the appellate courts can. But if you look at the appellate court analysis all across the board, they don't know what to do with Sandholm. You've got cases that say meritless or retaliatory. You got cases that say, well, it's
Councilman.
meritless.
You've read the cases.
Okay.
Please bring your remarks to a close.
All right. Well, all I can do is, I mean, if you want to cut and paste Justice Hyman's dissent, I'm happy with that. But for the citizens of Illinois, I really think you should take a hard look at Sandholm, a hard look at Reich, and take the steps that restore us back to the forefront of championing these rights instead of being the state that's behind everyone.
I think I'm with him.
Thank you for your time, and especially for the consideration of this question.
Because what he's basically arguing for is we need to be able to not be sued by people for just speaking the truth. That's really the side that he just advocated for, and I almost want to sneak ahead to go look at the opinion, but I want to see the other side's argument. But that's what this gentleman, it took me a long time to realize what he was really arguing for, just because I'm looking at sometimes as the big corporation, and sometimes you want them to lose. Well, actually, but the correct framing of this is investigative journalists reporting on possible corruption in the government. That's the most essential, and that's, I think, what he was trying to stress is like, if we need, this is your, basically he was telling them, this is your Seminoles anti-SLAPP case. This is what you want to have happen. You have a comment by the governor. You have a unelected appointee. You have a directive that wasn't really based on the facts, apparently. An investigation happened, and then you had a news agency reporting on it, and then the guy who got reported on wants to sue him for defamation and make him use all the resources. So I hope the Sun-Times win and Mr. Novak's win this case, but let's see what the defense or the initial plaintiffs and now the appellees, meaning that they lost. Wait, what exactly did they lose? So, like, what happened? Okay, so the ICPA is an anti-SLAPP statute. Okay, SLAPP is just a term. So both lower courts affirmed or just ruled in favor of defendants denying defendants' special motion to dismiss. So defense wanted to dismiss the lawsuit. That was denied. And request reversal in accordance with the First Amendment. So they're asking for further, so they going hard in the paint for everyone else, and they're requesting reversal in accordance with the. Yeah, so they want to know how do you read the ICPA really? So they're asking, that's what they're asking them to do.
Good morning, Your Honors. My name is Philip Zizuk, and I represent
the
plaintiff, Mauro Glorioso, who is present in court this morning. Counsel, may it please the court.
Let me get my chair, man. I can't keep going.
What the defendants are trying to do in this case is not only argue for a judicial amendment of the Citizen Participation Act, but now
don't tell me they messed up writing the act, and now they want to just chill everyone's speech until they amend it.
I'm hearing for the court to basically rewrite Sandholm In the circuit court and in the appellate court, they were standing behind Sandholm and embraced Sandholm. And their argument was, we were seeking to participate in government.
Hope I didn't. Sorry about that, guys.
And we were seeking a favorable governmental result. That is the first test under Sandholm. That is the first test that is their burden in making a motion under the Citizen Participation Act. In fact, they did try first to argue the merits of the case and the lack of merit in Mr. Glorioso's complaint before they filed an ICPA motion. They filed a 2619.1 motion to dismiss for pleadings issues and on the merits. It was denied. Their motion for this clear violation of speech rights came 60 days after the denial of their pleadings motion. And they titled that a motion to dismiss under the Act, or in the alternative, for reconsideration. And so Judge Sheehan in the circuit court denied both prongs of their ICPA related motion, and then finding that it was not a slap. And then the appellate court on 2 occasions found the lawsuit is not a slap, undertaking the correct procedure. And the lack of dismissal on pleadings ground wasn't properly before the appellate court because they took an interlocutory appeal solely on the ground of the denial of their slap motion. So the first question that has to be answered is whether their speech was as a citizen seeking participation in government, and did that speech constitute a genuine aim to get governmental relief? And the answer is no. They reported a news story on the basis of this anonymous OEIG complaint. That's all they did. They reported news.
Counsel, are you saying that a news story can never satisfy the requirements?
No, Judge, it can. And to even go back a second, what their primary argument in their briefs in this court is that speech on matters of public concerns should be protected under the SLAPP Act. And I emphasize should be protected because it is not protected now. To have speech protected under the ICPA, it has to be speech with a genuine aim to achieve governmental relief. There's no request for relief here. So that
why would a slap statute need to maybe I'm misunderstanding what the Illinois Citizen Participation Act is. Because why would you need to seek government relief? The court is the I'm sure I'm not understanding it right, but
news.
What was the question?
And to even go back a second, what their primary argument in their briefs in this court is that speech on matters of public concerns should be protected under the SLAPP Act. And I emphasize should be protected because it is not protected now. To have speech protected under the ICPA, it has to be speech with a genuine aim to achieve governmental relief. There's no request for relief here. So that if a news article, if media speech seeks a governmental relief, a government result, Yes, it can be protected. In fact, we know that that is not only the achievable, but has been determined, because that's the Ryan case. Contrary to what defendants have argued in this case, the Ryan case was not speech related to a public concern. It was a matter of public concern, whether judges were leaving the courtrooms early on a daily basis. But what the court found, I'm sorry, what the court found was that it not only was on public concern, but it sought favorable government relief. And it was that was the basis for the court's holding, which said, perhaps most importantly, and I'm quoting from the court's opinion, perhaps most importantly, the report sought comment from the Illinois Supreme Court and Chief Judge Evans on the investigation's findings and urged them to take action. Such activity is well within the scope of paragraph 17 of the Act, and it was only because of that activity that it was found to be protected. The same thing occurred in the
So, counsel, are you saying that had the news story included some phrase or discussion that said, this investigation continues and we urge the PTAB and all of their actors to get the assessment right on behalf of the taxpayers, would that have cured?
Well, here's the bottom line. They didn't request any relief of any kind. They didn't say, for example, we think that PTAB has to investigate its own procedures to ensure that political bias is not entering into determinations of people's tax appeals. Or they didn't say Glorioso should be fired immediately. Or they didn't say, we find that this report is just facially conclusory and that Glorioso should remain an employee in good standing. They didn't seek anything. They didn't seek modification of PTAB standards. They didn't suggest any relief.
Well, counsel, back to Justice O'Brien's question, is that if they had sought some relief that was clear, would that have cured the defect?
I think it's if they requested government relief, if they genuinely had speech that aimed for a favorable governmental result, it could have, but it didn't. And
in the story. You're saying in the story.
Yes, end of story.
In the story.
In the story.
They didn't seek this relief in the story. Is that
yes,
what you're
because otherwise, for example, one of the flaws of the dissent in this case is that he says, Justice Hyman says, something like this. Perhaps reading the report could lead PTAB to check its own procedures and determine if anything needs revision, if it does. I mean, it's so speculative, and it puts the burden on the newsreader to think, well, maybe we should do this. But the Act doesn't rely on third parties. The Act relies and puts the sole burden on the speaker to show that it was participating in government, Not that it was exercising a First Amendment right of report, but that it was furthering, it was participating in government to seek and procure favorable government action. That is entirely the burden of the movement in these ICPA cases. Here, they just had a news article. And that's the difference between the Garrido case that counsel cited.
Time left in this thing?
There are two Illinois cases that went through the appellate court, both of which were speech related to, they consisted of negative comments about aldermanic candidates. They're unqualified. They don't live in the district. They really live here. They shouldn't be elected. What the courts in those cases said, they didn't say, oh, this is a matter of public opinion, so it's protected under the SLAPP Act. No, they went through a total analysis and found that this is speech urging the electorate, which is a specifically protected class under the ICPA, on a level with government. It was appeals to the electorate to vote a certain way in an upcoming election. And the court said, correctly, that was speech in furtherance of government relief. And so it is protected under the Act. These words of the court going through the analysis, it wasn't based on public opinion. It was based on legitimate, genuine claims or requests for governmental relief, how the voters were going to vote in this election. And there was advocacy behind that speech. There's the Bach and Hatch appellate court decision. That was the one that concerned a blog that reported Seventh Circuit Court of Appeals decisions and posted comments on them. The appellate court in that case said, well, yes, it is speech on a matter of public concern, but it's not protected under the ICPA because you're not taking any kind of position. You're not seeking any kind of relief. You're not urging the electorate, the public, or government to do anything. You're just reporting news. And that is what happened in this case. And that is why the defendant's speech in this case is not an ICPA case. And the motion was denied in the trial court, in the appellate court, and now they're trying to get a result in this case that speech on a matter of public concern that doesn't seek any relief is protected under the ICPA. Now, the difference between our situation in Illinois and the Texas statute is that there is a Texas statute that does say that statements on matters of public concern are now protected, and you can file a SLAPP motion, and you no longer have to prove that it was in further of seeking governmental relief. Illinois' Act has not been amended. We still have the same SLAPP Act that we've had for more than 10 years. There's no amendment. How can the court now say, oh yeah, now matters of public concern that don't seek government relief are protected? It can't happen. Now, the legislature could consider an amendment, and maybe it will at some point, but it hasn't. And our SLAPP Act still says you need speech that is genuinely aimed at procuring favorable government action in order to have a valid SLAPP motion.
So, counsel, if we oppose the appellate court and rule in your favor, what happens?
You won't oppose. If you rule in my favor, the appellate court agreed with me. It's just this opinion, this dissenting opinion from Judge Hyman. that has disagreed with me.
Well, what happens next if we agree with you?
The case proceeds like all civil cases do.
So it goes back to the trial court and you have a trial. Is that what you're asking us to do?
Yes, the case should proceed. Because the SLAPP Act says what it says, we haven't been able to get out of the gate. This case is several years old, but the minute they filed their SLAPP motion, discovery was stayed and everything stopped until there's a resolution of the SLAPP issue. So yes, if there is a remandment, if they didn't file a petition for leave to appeal, the mandate would issue to the circuit court. We'd appear for a status conference.
Now you gotta prove a defamation case 2 years later.
In some of these SLAPP cases, you can do some limited discovery to figure out whether the elements are met. Did you have any discovery at all in this case?
No, we did not. And I don't think we had legal arguments. We didn't have factual arguments.
She knows it.
On its face, their articles don't seek any governmental relief. They report news. And as I said, Ryan is a perfect example of a news article or news reports can seek government relief. They didn't. I also want
there were two steps to the analysis.
I want to hear his reply to the government
certainly
relief.
we want to give you an opportunity.
Oh crap, she's about to ask a question. Hold on.
Section 10 of the Act protects information and reports even before it gets to opinions and arguments. Obviously, the legislature saw a distinction, and so did this court in Walsh. Participating in government is informing the electorate about possible needs for reform and getting to the bottom of what's going on. With respect to judicial amendment, I hesitate to say this, but commentators are fairly uniform in saying the judicial amendment was when this court inserted solely into the Act. And those are referenced in our reply brief and the amicus.
Solely is probably what says that you need to be seeking government relief.
I don't believe that term served any purpose other than to sow confusion with the application of the Act. Certainly, the Act does not make these kind of distinctions. It talks about the right to speak freely and otherwise participate in government, and then sets up a system for identification and adjudication under Section.
We still live, huh? We still live, huh? We still live, huh?
5. And then in Section 15, it says you're protected regardless of intent and purpose. That's what they meant. But what's the safeguard? The court's concerned about safeguard. The court's concerned about screening. The court's concerned about access. All that's true. What the legislature decided to do is in 20C. After you file the motion, the judge shall dismiss unless the court finds the responding party has produced clear and convincing evidence that the acts of the moving party are not immunized or not in furtherance of acts immunized from liability in the Act. The statute's very clear. You have an early hearing. You ask for the proof. If it's meritless, well, then obviously the intent couldn't have been legitimate on the plaintiff's part. If you have other factors, such as the appellate, but I really think that it just comes down to three things. Three things that the Constitution says, the United States Supreme Court says, this court has said in Celaya Technology and in Imperial Clothing are much closer.
What is it?
Was it knowing? And was it factual? And was it false?
Knowing.
Here we have an uncontested affidavit. We have a complaint that sort of says that all these inferences and depictions took place, but nowhere do we see anything that actually turned out to be factual. And the only facts we have are who was the governor talking about? Who was he investigating? Who is he going to get to the bottom of? Plaintiff.
Counsel, could you respond to the argument that how this procedurally played out, that certainly there was a traditional motion to dismiss under 2615 and also 2619, where the defense had an opportunity to bring all of these kind of issues to the forefront, to the court. All possible defenses, pleading infirmities, all of this were brought to the court, and the court denied all those motions. How does that figure into our analysis of what your opponent says is a two-part test, but at least on this issue of merit?
Well, it's all de novo. I mean, it is all de novo. And partly this is, as the New York Times, the Global Relief case says,
De novo means that the court has to look at the case brand new, like it's right in front of it. They don't have to consider the prior court's determinations or give any kind of preference necessarily.
Time.
Help me do. Why is it all de novo? Why is it? How does this court?
Because they're all questions of law. This is a case where we had to take a complaint, and we argued.
And all of those issues were before the trial court, and the trial court rejected them.
Yes, it did, and we believe that that was error, and so does Justice Hyman, and for the reasons Justice Hyman stated. And I think that I can't even understand, how do we do an innocent construction analysis when all we talk about is a plausible defamatory construction? Well, that's not even the Kickstarter for the innocent construction argument. You still need a false fact, as Imperial teaches us. And then in Green, this court teaches us we can't balance. We have to go look and rule out the alternative innocent constructions.
So
we never even did that.
The structure of our analysis should be on the issue of meritorious versus meritless. What was before the trial court on the 2615, 2619? What arguments were made? What affirmative matter was raised? And we should be looking at all of that to make this determination? Is that the universe of what we should be looking at?
Certainly you can, but you don't have to. You could end this case right now. Say, where's the actual malice counter affidavit? It's over. That's what the Constitution requires. That's what the Supreme Court requires. The United States Supreme Court. You could end it right there.
But the trial court rejected that.
I don't even think the trial court even looked. We didn't get the statutory hearing in this case. We never did.
You had a 2615, 2619.
We filed them, yes, the 2619-1, because we said that pressured and pushed under the precedents are not precise facts under imperial clothing, so we should win on the pleadings. And we also said because, hey, you didn't attach the rest of the documents. But at that point, we didn't have the final report. Plaintiff was still trying to block it from publication, so we didn't have that with us. We didn't get that till later in the process. And because even Sandal says, and the appellate courts I think are all hung up on can we decide this even under 2615? Do we have to wait till 2619? I think that's
Isn't it crazy how most of the legal process is just people trying to understand how all the laws that we've written connect to one another and all of the policies? And because you got to understand, when we say law, like we saying things like reasonable. So you got people trying to figure out what's reasonable, but giving this interest and that interest and this code. And then you have the formalities of who has the burden and how you're supposed to be and what position of the case it is, like who gets to go first and what kind of presumptions are you being given? Do you have to rebut presumptions? Like, are there defenses that would also render the case moot? There's so many because at the end of the day, we're trying to be precise about what we're saying. Because we can't just be like, like it'd be hard to conduct like appellate proceedings, if people weren't speaking precisely about what they meant. You can't just like point, and scratch. But when words have to be precise, it takes a lot of time. You have to really know the universe of what you're saying, because if you don't know what you're saying, you can't be definite. And if you're not definite, you're not really saying much. So, yeah, it gets tricky.
All beside the point, that's dancing on pins. I think
I'm about ready to go look at the
20C
opinion. Let's go look at the opinion,
You can do
ladies and gentlemen. Here we go. In the Supreme Court of the State of Illinois, Mauro Gliricio, Justice Overstreet, delivered. Let's see which one is Justice Overstreet. Because the sister with the white hair was asking a lot of questions. Well, let's see. It's not what I wanted, not what I wanted. That's not what I meant. Oh, this guy. Okay. All right. Let's see what the justice said. Did he sign my law degree? Yeah. I'm looking at my law degree on the wall, and Justice Overstreet signed that. Signed it right there. All right. Anyway. All right. Let's see what the good justice had to say. Okay, and most of the justice concurred. Justice Rockford took no part in the decision. All right. Plaintiff's complaint. The defendant, Chicago Sun-Times, published an article captioned "President's Chicago Tax Appeal on Trump Tower is under investigation." So that was it. And then the subheading of the article read, "State Inspector General Pritzker Administration looking into allegation a Republican state agency had pressured staff to slash by $1 million." So this is highly politicized stuff. So it's actually paid by Donald Trump. Okay, so they gave Donald Trump $1 million tax break. The article falsely identified, according to the complainant, the article falsely identified the plaintiff as being under investigation for pressuring PTB staff to grant based on political loyalty rather than the merits of the case. In addition, the complainant alleges that the article falsely stated the plaintiff did this to cut the president a break, and that he rejected the staff's decision to deny Trump any award as a consequence of the plaintiff's political motivations, which were, so basically we get it. They basically said he was politically compromised. And they republished a print version of the article titled "Perez Tax Appeal Under Investigation." Probing Perez to investigation looking into a Republican state agency head pressured staff. Pritzker's dump official who pushed for Trump to get. All right, so these articles are kind of definitely painting a narrative of this guy, Gump access official who pushed for. Okay, so they're painting him as like a Trump Republican operative who gave someone an unfair. Okay, counts 1 or 2 of the complaint alleged that the cause of the action was for defamation per quad. What does that mean? Per quad. Per quad is a Latin phrase used to illustrate that the existence of a thing or an idea is on the basis of external circumstances not explicitly known or stated. Legal example. Statements are considered defamatory per quad if the defamatory character of the statement is not apparent on its face. Also, like inferred. The plaintiff has to prove the actual monetary damages. You have to prove more, I guess, for damages. Counts 1 or 2 defamation per quad. I think that means per inference, based on the publication of all these different articles, respectively. In support, these counts allege that there have been confidential anonymous complaint filed. Counts 3 and 4 allege cause of action based on defamation per se, based on the other 2 articles. Per quad and per se. per quad, I took to mean defamation that's implied, and per se is defamation based on. By which, through which. Defamatory on its face. Yeah, they're much more difficult to prove. Statement starts typically more backhanded. So per quad is backhanded compliments as opposed to a straightforward. Yeah, so that's pretty what I'm basically just trying to make sure I'm understanding legal stuff. Okay. It's not a fair report. So they're basically saying all the Sun Times articles did not constitute a fair report of the contents of the anonymous complaint. So if there's a complaint and it doesn't say that, and then you say it says that, that's kind of a good way to show actual malice, because the defendant knew they were false and acted with reckless disregard to their falsity. That's all you really need for defamation and for it to be actually per se or per quad defamatory. But let's see what the court had to say. Wait, we can go to the beginning to see what the court ruled, right? Okay. Defendant, Sun Times Media, appealed the judgment of the appellate court, which affirmed an order of the Circuit Court of the Cook County that denied their second motion to dismiss the defamation complaint by plaintiff Mauro Glaricio. On appeal, defendants contend the complaint is subject to dismissal of as a slap pursuant to Section 15 of the CPA. For the following reasons, we found lawsuit is not a slap and affirmed. Wow. So they have to litigate this nonsense further. Now, let's see who Tim Novak is. I know Tim Novak was not happy about this. Tim Novak, where you at, buddy? Where you at? I know you're not happy. Government corruption, which I don't see how that, like, the legislator has to do something about that, because if there's that much smoke, but I don't know, the law is written the way it's written for a reason. But like, I guess we can read the rest of the opinion. But let's see, when was the opinion given? It was given, last year sometime. Okay. Yeah. I don't want to see the appellate court. They went through it. Yeah. This is a pretty long opinion, man. Yeah, so long story short, in order to, I feel like I could be wrong, but in order to get a case overthrown or dismissed based on slap in Illinois, is that it has to be completely baseless, without merit, and retaliatory meritless. Oh. Yeah, all right, folks. That's the stream. Did my thing.